What officer? What officer? What officer?
ಹೇಳಿ ಸರ್.
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Finally.
Which year matter? You have filed application. You have filed application. Application list for orders. For orders on that. Which year? Your earlier application is allowed? Seventeenth. For orders on LR application.
That's 2012 matter for final hearing.
Just a minute.
2012 matter for final hearing minutes.
So somebody is speaking through VC.
I request for a date minutes.
2012.
Yes, minutes.
Have you filed earlier application?
2 minutes.
File earlier application.
Please.
My lord, 2008 matter, my lord.
Matter is admitted and posted for early final hearing.
Yes.
You must contest it.
Please.
My lord, one submission, my lord. 2008 matter, my lord. The matter should be posted final hearing, my lord. The last date was in 2019. And then after that, the matter was not posted, my lord.
File an application.
It's not there, my lord.
That's the cite the reason and file the application. Madam. Fifty-three now. ಬೇರೆ ಲಾಯರ್ ಮಾಡ್ಕೋತೀರಾ? ಯಾರು ನಿಮ್ ಲಾಯರ್ ಈಗ? $53 ನಾ? ಒಂದು minutes one. ಅಪಲೆಂಟ್ ಅವರು ನಿಮ್ಮ ಹೆಸರು? ಮಹಾದೇವ್. ಅಪಲೆಂಟ್ one of the appellants is present before the court. He seeks to engage another lawyer. At his request, is this matter in December. December
Lordship time. Lordship time. Lordship, kind permit.
Wait. Him lawyer ಹೆಸರೇನು? Rao Associates. Rao. ಡಿಸೆಂಬರ್ 2ನೇ ವಾರದಲ್ಲಿ ಅಷ್ಟೊಳಗೆ ಬೇರೆ ಲಾಯ್ಟ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್. ಎಸ್
Serial number 37, please, my lord.
wait. It will be page wise.
Please.
ಕೇಸ್ ನಮ್ಮ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು? 4. Memo for retirement ಇದೆ ರೆಸ್ಪಾಂಡೆಂಟ್. ಕೂತ್ಕೊಳ್ಳಿ, ಕೇಸ್ ಕರೆದಾಗ ನೋಡ. ಕೂತ್ಕೊಳ್ಳಿ. Before admission, at the request of learned counsel for the respondents, this matter next. Bill number 44. Speak through the mic.
Number 40. The lordship said had this matter, and I had also asked my client to come over because we find out whether the person settlement. They could not make it. The lordship may have it on Wednesday and Thursday.
Matter is settled.
No, I mean, we are yet to. I have to ask him to come out. I told him to come out.
41 is probate matter.
Not 40. Number 40. The lordship said had this matter in detail. Thereafter, it was also thought whether the matter can be settled because of the situation. So I have told him to come over. He said he will be coming here by the Tuesday or Wednesday.
Which date you want?
Wednesday.
The request of learned counsel.
I will inform the other side also.
The request of learned counsel for the appellant. List this matter on 9th to explore the possibility of settlement.
Serial number 37, please, my lord.
Yes.
Serial number 37, I am for the appellant. Senior is coming, my lord.
My lord,
Senior
in this case, appear for respondent. This VP Kulkarni is not well. 1 week stay may be granted, please, my lord.
Kindly, your lordship, pass over it, my lord. Senior is on the way. Senior is coming.
So he says the advocate is not keeping well.
Please, my lord. VP Kulkarni is not well. Next week, please, my lord.
No, respondent's advocate.
Now he has sent a message.
Yeah, morning I'll send them.
It is 37. It is submitted that the learned counsel for the respondent is not keeping well. Is this matter on?
Next week,
Which date you want?
Monday, your lordship.
please, my lord. 14th or 15th.
Monday. Yes, Monday.
Much up.
Public.
Pass out. Am I there? You have no objection? Application to bring the LRs of whom? Who died? Respond number 4. Memo is filed in the top respond number 4A. Stop. It is stated that respondents number 4B and C are the LRs of respond number 4A. Memo is accepted. Respond number 4B and C are treated as the LRs of respond number 4A. This is respond number 4A. ಇದೇನಾಗಿದೆ ಐ ನಂಬರ್ 1 of
Yes, sir. What? A and B.
you appear for A to see application I number 1 of 2021 for condonation of 282 days filing the application to bring the legal representatives of deceased respond number 4 is allowed, delay is condoned. I number 2 of 21 is allowed, abatement is set aside. I number 3 of 21 is allowed, and the legal representatives of deceased respond number 4 are allowed to come on record, appellant to carry out necessary amendment and to furnish amended cost type. Yes.
What is that from last time we hearing only repeated that.
University to whom? Where is the acknowledgement? Order again. Yes. The Subramania or the learned advocate for appellant is permitted to retire in terms of order dated 21/10/2022. The matter is listed today. Name of the appellant is shown in the cause list. None appears. None appears for the appellant. None appears for the appellant. This matter on Monday. The last for appellant, Your Lordship. Next time. Police protection for what?
I appear for respondent number 1, my lord, in this matter. I have filed memo seeking permission to retire from the matter.
Just a second. Yes.
I have filed memo seeking permission of this honorable court to retire from the case for
Yes.
want of instructions, my lord.
Yes. Your client is here.
That's
Before the court.
That's all right, my lord. He wants to engage some other advocate.
Now, what is the application?
Directing the local police to directing to local police not to put up obstruction, taking legal action against. After that, on 23 days, 2020 as a traffic concession. Son of us were considering the area number 1 of 50. Allow by 1 of 50 directly responded not to put up obstruction. They were point of that he has instructed to leading a right matter. And both the subways, the lawsuit has ordered a number of attempts set up. Now taking that advantage again he has violated the order and put up actions. That purpose, of course, the local police are not able to.
Just a second. English ಗೊತ್ತಾಗತ್ತಾ? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅಲ್ವಾ? ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಬಾರ್ದು ಅಂತ ಹೇಳಿ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಗೊತ್ತಿಲ್ವಾ? ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ತಂದೆ ಪರ ನೀವು ಬಂದಿದ್ದೀರಲ್ಲ, ಈ ಕೇಸ್ ನಲ್ಲಿ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ, ನೀವು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಬಾರ್ದು ಅಂತ ಹೇಳಿ. ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದ್ದೀರಾ? ಯಾವಾಗ ನಿಲ್ಸಿದ್ದೀರಾ? ಅವ್ರಿಗೆ 95 ವರ್ಷ ಆಗಿದೆ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಗೊತ್ತಿಲ್ಲ ಆಗಿತ್ತು, ಯಾವ್ದು ನಡೆಯಲ್ಲ. ಕೋರ್ಟ್ ಆರ್ಡರ್ನ ಪಾಲಿಸ್ಬೇಕು. ಪೊಲೀಸ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಲಾ? ಯಾಕೆ? ಯಾವಾಗ ನಿಲ್ಸ್ತೀರಾ? ನಿನ್ನೆವರಿಗೆ ಕೆಲಸ ಮಾಡಿದ್ದೀರಾ? ಮೊನ್ನೆವರಿಗೆ ಮಾಡಿದ್ದೀರಾ? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಯಾವಾಗ? ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿಲ್ವಾ ಅವರು? Have you not filed complaint?
One of course the local police, but they
No, has he responded to your application seeking contempt for contempt?
Yes, that contempt application also is
Objection ಹಾಕಿದಿರಲ್ಲ ನೀವು. ಅವ್ರ ಕಂಟೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ objection ಹಾಕಿದಿರಲ್ಲ.
He is before son of us got playing innocence. But in there the local he has violating the order.
ಪೊಲೀಸ್ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೀವಿ, ಸ್ಥಳಕ್ಕೆ ಬಂದು ನೋಡಿ ಅಂತ ಹೇಳಿ. police report ಮಾಡ್ತಾರೆ. The application is filed in IN number 1 of 2022 seeking protection. ಏನ್ protection ಕೇಳಿದಿರಾ ನೀವು? The order is that he should not put up this. The application is IN number 1 of 2022 is filed seeking direction to the police to ensure that the first respondent against whom the order is passed on 23/20/2023, restraining him from constructing the structure in the suit property. Stop. In terms of order dated 23/20/2020, this court has restrained the first respondent from putting up any structure in the suit property. The advocate for the first respondent has retired, and in Mesreno, Narayan Swami, who claims to be the son of first respondent, is before the court. ನೀವು ಯಾವಾಗ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದೀರಾ ಕನ್ಸ್ಟ್ರಕ್ಷನ್? See, Narayan Swami, who claims to be the son of first respondent, submits that he has stopped the construction 3 days ago. Stop. However, the order is passed on 23/10/2020. Stop. Under these circumstances, this court deems it appropriate that the jurisdictional police should visit the suit property and ensure that no construction takes place till further orders. Police bartare, and the jurisdictional police has to report to this court by date. 14 ತಾರೀಕಿಗೆ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಕರ್ಸ್ತೀವಿ. ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದೀರಂತಾದ್ರೆ ಸಮಸ್ಯೆ ಆಗತ್ತೆ. ಅಷ್ಟೊಳಗೆ ಬೇರೆ ವಕೀಲರು ಮಾಡ್ಕೊಳ್ಳಿ.
I may be permitted to retire.
Students is permitted to retire. 14 ತಾರೀಕಿಗಿದೆ. ಏನ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆದ್ರೆ ಅದನ್ನ ಪಾಲಿಸಲ್ಲ. ಕುತ್ತಿಗೆಗೆ ಬಂದಾಗ ವಕೀಲರು ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ ಅಂತೀರಾ? ಹದಿನಾಲ್ಕಕ್ಕೆ ನೀವು ಬರ್ಬೇಕಂತಿಲ್ಲ, ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಬರುತ್ತೆ. ನೀವು ಅಷ್ಟು ವಕೀಲರನ್ನ ಕಟ್ಕೊಳ್ಳಿ, ಬೇರೆ ವಕೀಲರನ್ನ, ಅವ್ರು ಬರ್ತಾರೆ ನಿಮ್ ಪರವಾಗಿ. ಕೋರ್ಟ್ ಆದೇಶ ಮಾಡಿದ್ರೆ ಪಾಲಿಸ್ಬೇಕು, ತಮಾಷೆ ಮಾಡೋದಿಲ್ಲ ಆದೇಶ.
Serial number 5, appear for Serial number 5, appear for appellant, my lord. In this case, we are filing the memo for retirement, my lord. Kindly permitted to.
So have you produced the acknowledgement for having served the
Yes,
notice?
my lord. Page number 3, we have produced the acknowledgement.
How many appellants?
Only one, my lord.
Learned counsel for the appellant has filed a memo for retirement along with the notice dated 11/1/2022, said to have been issued to the appellant. The memo is also enclosed. Police postal acknowledgement is also enclosed. This court is satisfied that the notice is served on the appellant. Learned counsel for the appellant is permitted to retire from the brief. Registry to show the name of appellant in the cause title. This matter on 17th November.
Obliged, my lord.
The request of learned counsel for the appellant is time granted. Notice issued? Not yet issued. Issue notice on I number 3 of 2022, 4 of 2022, and 5 of 2022. The proposed legal representatives of deceased R1B. Pay the process.
8, S.K. Venkata Reddy.
At request 2 weeks time granted.
Maybe Gangadharappa.
Lord, I appear for the appellate.
Yes.
Lord, in fact, on both the appeals, RSA 1219 and 1218 of 2011, on the earlier occasion, my lord, I was permitted to retire from the case, but somehow the office has shown the name once again, my lord.
On which date order is passed to retire?
Made on 23/4/2021. In fact, my lord, the name of the party is shown in the connected appeal.
On 23/4/2021, the learned counsel for the appellant is permitted to retire
In both the
However,
appeals.
in both the appeals. However, the name of the appellant is not shown in the cause list in RSA 1219 of 2011. Registry to show the name of the appellant and list this matter on 17.
The
Yes.
name of my senior may kindly be ordered to be deleted.
Ordered.
Please, please.
Will allow the application. I number 1 of 19 to 3 of 19. File to set aside, file to condone the delay in filing the application to bring the LRs of appellant number, sole appellant, appellant, and to set aside abatement and to bring the LRs of deceased appellant are allowed for the reasons assigned. Delay condoned, abatement set aside, appellant to carry out the necessary amendment and to furnish the amended cost type. The appellant is permitted to bring the LRs. Yes. Paper book. You are for respondent. All right. This is matter for final hearing.
Well, that's for the appellant to demand.
Hmm.
Well, it's my request for 2 weeks time.
No, the cost was ordered on 17/12/2018.
Please, my lords.
Pay the cost today. Pass over.
My lords, we do not have instructions from clients, my lords. We are not able to contact him. And as per my instructions from senior, my lords, he will not be in court today. He's not in court today, my lords. He is unwell. We have to take instructions from senior as well as clients, my lords.
So you already filed the paper book.
Please, my lords, we have filed it.
Cost is not paid.
My lords, with respect to the cost, we are unable to contact party, my lords. We neither have his contact number, and we have already written.
Order dated 17/12/2018 says, in case the paper book is not filed within 6 weeks, every week you will have to pay cost of ₹100.
Obliged, my lords. We'll be able to calculate it and pay within a week, my lords. I need instructions from senior.
Then it consent for the appellant submits that the cost will be paid within a week's time granted. Yes.
English.
2 weeks. So if the is ready, why do you need 2 weeks? Two weeks time granted.
The required number 9, he remained expert before the trial court and also the appellate court.
No, he says he remained ex parte. Why do you want to take notice against him? Why don't you make use of provision of law which says the notice can be dispensed? Relief sought against him. And 4 times the notice is issued, it is not served. Now what you are supposed to do now? At request, week's time granted to take necessary steps for service of notice to the fourth respondent by a appropriate publication. Sorry? During the course of the day, learned counsel for the appellant submits that cost will be paid during the course of the day. This matter next week, after 2 weeks. Final hearing aega? For final hearing, this matter for admission for 2 weeks. Possible. Possible.
Matter, my lordship. They have questioned the degree of preliminary degree, my lordship. Already final degree has been taken place, against which an appeal also filed, appeal also dismissed, my lordship. Everything has been confirmed. Here, my lordship, first appellant and third appellant accepted their share and filed their memo before the FTP court, my lordship. Accepted
Against
this.
final decree, the appeal was filed before this court.
Not before
First
this.
appellate court.
Yes, my lordship.
When it was dismissed,
It was dismissed.
in that the proceeding appellant is also allotted share
Yes, my lordship.
and he has accepted it.
First appellant and third appellant accepted their share in FTP and filed a memo, my lordship.
First and
I have
third.
certified copy also.
First and third. Let's give the copy. Where is the counsel for appellant?
This matter is going on, my lordship, since one of the appellant withdrawn, the first appellant withdrawn the appeal, my lordship, by filing a memo. And third appellant, my lordship, she is also accepted her share.
Learned counsel for the respondent submits that the preliminary degree passed by the trial court, which is called in question, confirmed by the first appellate court, is called in question in the second appeal, is already executed and final decree is drawn. It is further submitted that the final decree against the order passed in final decree number 17 of 2011 on the file of senior civil judge Nanjan Good.
Principal district and session judge at Mysore. It has been concluded before Mysore RA, my lordship. RA has been
against judgment and decree passed in FTP 17 of 2011 on the file of principal civil judge, senior civil judge Nanjan Good. Appeal is filed in RA number
23/2018. 29/1/2021. It has been
23/2018 and the appeal is dismissed on
29/1/2021.
1/2021. Stop. Under these circumstances, the learned counsel submits that nothing survives for consideration in this appeal. None has appeared for the appellant. I'll list this matter on Monday for dismissal.
I'll produce that FTP order and
You file it in registry.
yes, ma'am.
Today itself you file it in registry. 2 weeks time granted. Which matter? What happened? Ready. Matter is already settled. You want to report settlement? Learned counsel for the appellant submits that there is a possibility of settlement. To report settlement, list this matter on 11th, 14th. Sorry? Since Srimati S. Sushila is designated as senior counsel, name of Srimati S. Sushila be deleted from the bug list. Password.
I appear for the respondent, my lord. 21.
Just a second. Counsel for appellant has filed a memo for retirement.
Please, my lord, this matter, it may be fixed early date beginning of hearing, my lord. So no, it was retirement. It's a super specific performance, my lord.
Where is the acknowledgement for having served the notice? Yes. Learned counsel for the appellant has filed a memo of retirement, which bears the signature of Malla Reddy, who is appellant number. Appellant number.
Maybe all the appellants was appelling, my lord. Mr. Sadashiva was appelling for all the appellants.
Appellant is Malla Reddy, designation is so. Yes, signed on behalf of all. Appellant number so and so. One A. Appellant number 1 of appellant number on the stack. He has received the papers on behalf of remaining appellants also. Learned counsel for the appellant is permitted to retire. Registry to show the name of all the appellants in the cause list. This matter on 17.
Much obliged.
Learned counsel for the appellant submits that process fee has been paid. Registry to issue notice. Notice to whom? 8. Respond number 8. Respond number 8. And what about respond number 4? Notice to respond number 4 is held sufficient. Yes. Sheshagiri Rao. Pass out.
My lordship. My lordship, LR application of R3, my lordship. I will file the wakalat for R8 or C, my lordship.
Learned counsel for
But the application may kindly be allowed.
Learned counsel for proposed respond number
R8 or RG.
R3A.
Yes,
R3G.
R3G.
R3A to R3G. Submits that he would file the wakalat and the applications for condoning the delay in filing the application to bring the legal representatives of deceased R3 and application to set aside the abatement, the application to bring the proposed legal representatives of deceased respond number 3 may be allowed. Accordingly, they have been allowed for the reasons assigned. Appellant is permitted to carry out the amendment and to furnish amended cost type.
25 appear for R11, Milon.
The appellant, my lords, recalling of order dated 16/9/22, my lords. When the matters were listed on 3 days, the cause list, my lords, it reflected the names of Sri Chandrasekhar and Jai Shri, my lords.
You have any objection? Respondent counsel, you have any objection for allowing the application?
No, Milon. I am also, actually, I am R11 bona fide purchaser. I am the aggrieved person. So, when date also fixed for the hearing. No objection.
Yes, I number 1 of 2022 is allowed. Order dated 16/9/2022, dismissing the appeal for non-participation is recalled. RSA 108 of 2011 is restored. List this matter on.
The date Kodisami. Hearing
24th.
Somara Nadidu is 7th.
There's my request for at least 2 weeks.
15th November.
14th ಇಲ್ಲಿ ಸಂ 14th ಗೆ 14th.
Yes.
14th.
Yes.
Obliged. Hearing final hearing ಸಂ.
Finally.
14th.
Yes. Who appears for respondent? Notice ಹೋಗಿದೆ ಮೇಡಮ್. ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ? ಹೋಗಿಲ್ವಾ? ಪಾಸ್. ಪಾಸ್. Who died? Sole respondent. Sole respondent died. Notice issued. Issue notice on I number 1 of 2022. Delay of 2022 to the proposed legal representatives of deceased respondent.
Delay is there in filing.
Notice. Will you accept wakalat?
Yes.
Will you accept wakalat?
I am for the respondent.
Understood.
The appellant died.
Respondent died and 30.
No, I think they are already brought.
Issue notice.
Appellant matra hakidare. Respondent copy is not given.
Issue notice.
Yes.
89, are you there, Prakash?
I appear for the appellant.
Yes.
Well, in this case, after hearing both sides, an interim order of stay was granted.
Yes.
Question of vacating the stay does not arise. Whether the appeal is admitted.
When the paperwork is filed.
He has served a copy on me.
Yes. List this matter for final hearing.
Whether the appellant number 5 has also died on 1/11/2022, that is 3 days back.
Yes.
I will have to take steps in respect of appellant number 5.
Number 3 has died. Learned counsel for the appellant to take necessary steps within 3 weeks.
Appellant number 5.
So yes, appellant number 5. So he has to file application. There is a death in one of the parties has died. He has to file an application.
In the meantime, files applications are.
This Jayaprakash.
Yes.
Counsel for respondent is insisting for early hearing.
Yes, I have no objection.
Meantime, you file the application.
Yes.
List this matter on 24th.
24th?
November.
Yes.
Yes. Use mic.
Filed application for new grant, my lord. I was not party in the both OS and the RM, my lord. First, the second appeal, both the appeals. My lord, there is a divergent finding, my lord.
Now we are concerned with these facts of this case.
My lord, as on date, my lord, I am in the position, my lord. I purchased the site in 2006, my lord. I am not aware of the any proceedings of.
Just a second. In 2006, you purchased site under registered sale deed. Date?
Twenty-seven 1/2006, my lord. From one Tejaswini, who is the defendant in the.
You purchased from Tejaswini. Then what happened?
I was in peaceful position, my lord. In 2012, I am applied for plan sanction and it is within the limits of.
No, when you purchased the property, whether the case was pending?
Was pending, my lord. It was not aware. I was not aware.
Then
Subsequent.
what case? Which case was pending?
Here is an permanent injunction.
Filed by whom?
By the first respondent here.
Against your vendor.
Please.
Then what happened to that suit?
The OS was dismissed, my lord.
Suit was dismissed. So
Then
when,
the RA was allowed, my
what
lord.
was the date of dismissal of the suit?
My lord. It was 13/9/2004, my lord.
13/9?
2004.
That's the date of dismissal.
Yes, my lord.
After the dismissal, you filed, you purchased the property.
I am not aware. I have purchased the
You
property.
purchased after the dismissal, but appeal was pending. Now appeal is allowed.
Appeal is allowed.
Holding that plaintiff is the owner. Plaintiff is the owner.
Plaintiff is the owner. Subsequently, they filed one more suit, my lord. That is for a mandatory injunction.
Just a second. Just a second. The defendant, your vendor, has she not filed any appeal? RSC she has not filed. When you came to know about this, dismissal of or allowing of appeal?
After they filed the execution or this thing, my lord.
Execution against whom?
Against the defendants there, my lord. They came near the property, then we
They filed second suit. They also filed second suit. No, you said there was one more suit.
Subsequently, my lord, they filed another OS for mandatory injunction.
Against
That
whom?
also against the same respondent. Against same the defendant. That also I was not made party, my lord. that OS was dismissed, again, they preferred RA.
So you're filing appeal against how many days delay?
In first one, my lord, there is 7,700 days.
Yes.
That's, so far as delay is concerned, plus I have not filed objection, because let's, categorically submitted from the date of the knowledge. They filed this and delay, I have not filed any objection. I will leave it go. But so far as the leave, seeking the leave of this, I have filed objection. But I think my learning is not, the facts are not properly these people. From the 685, OS number 685 of 92, it was filed for declaration and injunction against the LRs of my vendor. LRs of my vendor. Let's, during the
No, when you purchased?
I have purchased it on 24/12/1982.
22?
24/12/1982.
So you purchased the property prior to this appellant?
Yes, he is a second purchaser. Second purchaser. But when the suit was pending, my vendors LRs dispose of this property to Pandrajana. The purchasers comes on record. My suit ultimately came to be dismissed. On 13/9/2004. 13/9/2004, my suit came to be dismissed.
No, you filed suit against whom?
The LRs of my vendors.
LRs of your vendor.
My vendors.
Your vendor did not object. You are
They
no
did not object.
When your vendor died?
It was prior to filing this suit.
No, year. So you purchased in 1982.
Yes.
So after how many days or how many months or how many years your LR died? Your vendor died?
I'm pretty good. I have right now I have. But as on the date of the filing, this suit was no more.
So when the suit was filed?
The LRs were
92. Suit was filed in 92.
Yes, thank you.
So at least we can take that for 10 years. There was no yes.
And when the suit was pending, the LRs of my vendor, they dispose of this property to the, not this, his vendor's vendor. His vendor's vendor. The suit came to be dismissed, I filed a RA. I succeeded in RA. When the RA was pending, the two sale transactions take place. Is the second purchase. The second purchase. My degree came to me, reached the finality because my vendors, the LRs, nor the first purchaser did not challenge that order. Remained uncharged. Subsequently, the first purchaser he had enforced upon a little portion of my property which I have purchased. So I filed a second suit, OS number 653 of 2008.
For mandatory injunction.
It's for mandatory injunction.
That was decreed.
That is, once again, the suit was dismissed in the RA I succeeded. When the matter was pending, that the second sale was done in his favor.
When the second appeal was second suit.
Yes.
So is a purchaser in second round of litigation.
He purchased. The RA succeeded, his vendor did not challenge that order. And now he is before this. After Millard's success, I succeed in RA in the second round of litigation, there in the mandatory injunction. I filed that Millard's execution. He has already entered appearance. They filed objection application in the execution to set up their the claim.
So when you filed the second suit for mandatory injunction, he had not yet purchased the property.
He has already purchased.
But you are not aware. You are not aware. So your mandatory injunction for demolition of structure. So according to you, who constructed the structure?
That's the vendors of my learned friend. The vendors of my learned friend.
So what you say is,
yes,
by the time you filed the second suit, he had already purchased the property.
Yes.
So you should have sought mandatory injunction against him.
It was my specific allegations in the second suit was.
All right. You say his vendor constructed the structure by encroaching. But by the time you filed the second suit, that illegal construction was transferred
That was not within my knowledge. That was not within my knowledge. That's why I have filed a execution petition only against the judgment data. That is the vendor.
That is understood. But as on the date of filing of the suit, admittedly the property was transferred. Maybe the transfer is not valid.
Yes.
The infrastructure was in his possession.
So it was not in his possession. But according to me, the second transfer in favor of my landlord was not within my knowledge.
Forget about knowledge.
Yes.
Admittedly, he was in possession of that illegal structure.
He claims that he is in possession. I made a submission before this. My claim is it is a collusive transaction. Relatives. Interstate relatives. Just they wanted to defeat the very purpose of the thing.
You go back to your vendor's date of purchase. As on the date he purchased the property, he was not having any ownership. His vendor, because he's already lost a case.
They have sold the property.
So you have got a cause of
They
action.
have contested the
You have been cheated. You have got a cause of action, not against him, against your vendor.
Opportunity is given, my lord, with a limited purpose, my lord.
No. So when the first suit was decided, you are not in picture. Property was sold in 1982. You are not in picture. So this sale was questioned by filing suit in 1992. It's not declaration 1992. You purchased in 2006. So by that time you had already acquired the ownership. Your vendor's vendor had no title. So you obtained decree against his vendor's vendor, alva?
Yes, vendor's. And the second suit decree is against the vendor. But in RA they have made my vendor also as a party, my lord. RL Madidara.
Which RA? Second one.
First RL.
First RA Madidara.
How to? Subsequently, they came on record. They came on record. So I don't know whether they have whatever they say, they have a decree.
No, what is your stand? You know the law. So now you understand whether this court can set aside the decree which was passed in OS number 685 of 1992, like your instance.
Opportunity.
So by that time you purchased the property, the decree had become final. Why opportunity? Opportunity, why? You establish semblance of right in the property, then will be a good opportunity.
I have not contested the matter, whether
No, your vendor's vendor has contested.
I don't know to what extent, because they have sold the property, my lord. Whether they have contested properly or not, I don't know. Title, my lord. Yes, he has entered the agreement of sale in 1987, my lord.
Just a
Sale
second.
transaction.
Just a second.
Yes, my lord.
RSA 390 of 2013 is arising from OS 685 of 92. 685 of 92.
Yes, 685 of 92.
685 of 92 is filed based on the sale date of 1982
Please.
against your vendor's LRs.
Yes.
That suit was dismissed. Then when you filed the appeal?
Lord's appeal is filed in 2004, my lords.
2004.
RA number 143 of 2004.
Against LRs of your vendor.
Yes.
Right? Then what happened?
But during the pendency, my lords, his vendor's vendor who has purchased, he came on record. Came on record. Despite that, my lords, I succeeded in RA.
Just a second.
Yes.
You purchased in 1982.
Please.
Then to his vendor's vendor, when the property was sold?
Lords, according to them, my lords, on 17/8/1992.
17/8?
17/8/1992.
Just write to yourself.
My salary is 82, my lords.
So 92, you said 92.
Yes.
Sold by whom?
Sold by LRs of my vendor.
Again. What is the date of your suit? First suit?
Eighteen 1992. 18/9/1992.
Date of registration.
89, huh?
89/1992.
So by the time the suit was filed, your vendors LRs have transferred the property.
Transferred the property on 17/8/19.
See, the decree against the East vendors LRs, that has become final. So you want to question that? So you want to establish that sale deed dated 17/8/1992 is valid sale deed. And you want to say that sale deed dated sale deed dated 24/12/1982 is invalid. On what basis you can say so? No, the vendor has not questioned. Vendor has not questioned it for 10 years. How can you say so?
I'm a bona fide purchaser. I'm in possession of an opportunity, my lord. I'll establish before the
Opportunity is given to you. That's the matter is this state.
I'll establish, my lord. If I have a case, my lord, now, my lord, my only grievance.
So permission will be granted provided if you are able to establish that you can urge that 1982 sale deed in favor of the respondent is invalid. How can you say so? The vendor has not questioned it. It is not your case that the vendor had no title. You are claiming under the LRs of the same vendor. So you are admitting that the vendor had title. Vendor has not questioned the sale deed. His LRs question it. They don't question it. Suit is filed against the LRs after 10 years. Then you are also claiming under the same title. Then
They have not, my vendors, vendor, my lord, they have not contested the matter, my lord.
so what is your stand? Do you say that his vendor had no title? If that is the case, I'll permit you.
I have next week.
Not next week, today. We have spent 20 minutes for this. So what is your stand now?
My lord, I'll
See,
establish.
when you file an appeal seeking permission to come on record and to contest the matter, you should know on what ground you are going to contest. This was filed in 2013. Even after 10 years, if you are not in a position to say on what ground you are going to contest it, what is the point?
This appeal, my lord. I have not stated, only I have stated, my lord, I have not made party. Opportunity is given, my lord. I'll establish. My prayer is also the text and my lord. Now, my lord, I am in possession. They have filed an execution, my lord.
Understood.
All of a sudden, if they tell that.
Not all of a sudden. Not all of a sudden. It's 10 years now.
They are also in knowledge of that. I have purchased.
No, it's 10 years.
My
Why do
lord,
you say? Why do you say all of a sudden? No, understood. Now, why do you say it's all of a sudden?
Now they have filed the execution, my lord.
So you filed appeal in 2013. Then how it came all of a sudden?
Notice has been served. Now it has come up, my lord.
What is that you have built?
I'm staying in that house, my lord.
Distance, huh? 2000? Mr. Hegde, instead of seeking demolition, why don't you purchase that house?
Sir, may I make one submission with the permission, Lord, sir? My party is something.
Sorry?
82 years. Because he doesn't have any LRs also. Lords, in fact, I advise my party. It's a demolition of the house is really affects somebody's daily purchase. Why can't you sit down and compromise? And in fact, last time I suggested
We are willing, my lord.
other than they can sit down and
Merits, my
work
lord.
it out. I think his interest will be protected and the interest of my old person is also.
We are ready,
So
my
I
lord.
think
You must make an offer. The offer should be attractive to that old man of 82.
Please, my lord. We are ready, my lord. Of other than the.
What is the offer?
My knowledge, my lord, up to 10 lakhs. We are
10 lakhs?
ready, my lord.
Where is the property? In which place? What is the current market value?
Last. When I talk to my.
What is the current market value?
I mean, option. I don't have any other alternate, my lord. I am ready for settlement, my lord. Willing and ready for settlement.
So this entire portion is in his possession. Entire portion of the property, purchase portion of it, not entire portion. So how much portion is in the possession?
But it's yes, just lost about 20 by 20. I think 20 by 20. 20 by 30. Sorry, 30 by 40 sides. 20 by 10.
You have also constructed house. It's open.
Not before the manor. That side I have constructed. I'm living there.
He's not disputing. He's not disputing. In entire set you have constructed. In entire set you have constructed.
Other than merit, my lord, because
Portion of the construction falls in his land. Learned counsel for the appellant and respondent submit that they would explore the possibility of settlement. This matter. On 23rd November.
Hotel execution is there. Last time I have given an undertaking that will not precipitate the matter.
Undertaken given by the learned counsel for the respondent on the previous state of hearing shall continue till next day. Yes.
My friend could raise in the light of the recent judgment of the apex court, there is a friendly objection regarding the maintaining issue of notice.
Sure.
Issue of very notice in this case, I am taking an exception.
The notice is already issued. Now, to understand that judgment, how to ask. I need to know the facts.
I just take
Yes.
1 minute. This is a partition suit filed between the brothers. Then the suit was dismissed. Then appeal, the suit was decreed, and the appeal file was dismissed. Against that, my learned friend has come up in appeals. Then the Honorable Supreme Court has, in paragraph 54, this is what the court has said.
This is relating to some adverse possession, right?
Regarding substantial question, what the Honorable Supreme Court says in paragraph 54.
No, in one more paragraph, there is also a reference because I had an occasion to refer to this judgment.
Regarding the issue of notice, what the Supreme Court has said. After the amendment, a second appeal can be filed only if a substantial.
What you are saying is substantial question of law is to be framed, then notice has to be issued.
No. Substantial question of law has to be framed by him. That is not gone. My lord could change it, but he must make out a case through substantial question of law. The instant case, he has framed a substantial question of law. My lord will kindly see page 176 of the paper book. None of the questions raised has never been even urged before the trial court or the first appellate. So therefore, that cannot be treated as a substantial question. What the Honorable Supreme Court says is only if there is a substantial question framed by him, then my lord will get the jurisdiction.
Good. Read paragraph.
Paragraph 54. They are quoting an earlier judgment. Paragraph 3 of the earlier judgment. After the amendment.
On a lighter note, whether the judgment says that the substantial question of law can't be amended.
No, it can be amended, but first he must make out a case on that basis.
Apart from the substantial question of law framed by him, the court finds that there is one more substantial.
That's what this says.
Taken away. The jurisdiction is
No. First he has to make out a case. Then only your lordship will get his jurisdiction. That's what I
read.
After the amendment, a second appeal can be filed only if a substantial question of law is involved in the case. The memorandum of appeal must precisely state the substantial question of law involved, and the High Court is obliged to satisfy itself regarding the existence of such a question. If satisfied, the High Court has to formulate substantial question of law involved in the case. Appeal is required to be heard on the question so formulated. Then please see paragraph 4. It has been noticed time and again that without insisting for the statement of such a substantial question in the memorandum of appeal and formulating the same at the time of admission, the High Court has been issuing notices and generally deciding the second appeals without adhering to the procedure.
In para number 4, what Supreme Court is saying is, without formulating substantial question of law, the appeals are decided on merit. That is not the procedure. While admitting the case, you have to frame substantial question.
No, that's no doubt about it. But what I'm trying to
that is not the import of the judgment. Not the import of the judgment. It only says appeal can't be decided without formulating substantial question of law.
That's when there is no confusion on that.
It doesn't say even for issuing notice on admission, the substantial question of law has to be framed and court has to be settled.
First 1 minute. After the amendment, the memorandum appeal must precisely state the substantial question.
Yes.
Involved, and the High Court is obliged to satisfy itself regarding the existence. If satisfied,
Yes.
High Court has to formulate. Then Miller. So 2 stages are there.
Yes.
First, he must make a formulated question.
Yes.
And then on that question, if the High Court is satisfied,
Yes.
then it has.
Yes. Now we have to hear him to satisfy myself whether the substantial question of law framed by him arises or not. That's what the judgment says.
But in
Not
the
to say,
instance-
not
in the
say,
instance
just a
of the
second.
Questions he has
No,
formulated.
no, whether the questions which he has formulated is a substantial question of law or not, this court has to decide. For that, I have to hear him. Now, without looking into the substantial question of law, without understanding the facts of the case, can I say that the substantial question of law framed by the appellant is incorrect? I have to hear him.
Yes, please.
Yes.
For partition.
Where is the genealogy?
Along with the appeal. For the 7 brothers and sisters.
All right. So one brother filed a suit.
One brother filed the suit.
Ah.
But the last brother was no more. And his LRs are parties in the suit. Or one
Property belonged to whom?
property was granted by the land tribunal in favor of the third defendant. That is the A schedule property. B schedule property is the land.
Just a second. A schedule in favor of one of the brothers.
Third defendant.
One of the brothers.
One of the brothers. Muttaya.
B schedule.
B schedule was granted to the first defendant, Babanna Kannada,
By land tribunal.
by land tribunal. It's a common order.
Only 2 schedules.
Only 2 schedules. For the A schedule measures around 5.5 acres of agricultural land. B schedule is around 67 cents of property comprising with house, where the first defendant is residing. But after granting of the occupancy rights, but in the year 1988, one of the brothers, that is Manjuna, filed a suit for partition, seeking 1/7 share, contending that the father, Neelayya Kannada, was the tenant in respect of these properties. Occupancy rights
More than one of the family.
on behalf of the family. One thing to be noted is, as on the date of grant of occupancy rights, father was alive. Father was alive. So still, the third defendant is not the eldest member of the male member. It is the first defendant who is the eldest male member. So, Lord, the third defendant who is granted with A schedule.
That is appealed by whom? Third or first defendant?
Third defendant.
First defendant did not file a appeal.
First defendant supported the plaintiff in the trial court.
That is for A schedule property.
A schedule. B schedule.
B schedule.
He is granted with B schedule. But still, he supports the plaintiff because ultimately, if it is partition,
Understood.
he will be in an advantageous position because he has granted 65 cents or so.
All right, understood.
Yes. But third defendant contended that it is his individual grant. He obtained lease, hold rights from the owner, that is the Dharmasthala Manjanatheshwara Trust.
Which year?
Specific year is not stated, but it is much prior to the coming into force of the Land Reforms Amendment Act.
That is understood.
Yes. And he filed form number 7. First defendant also filed form number 7. Plaintiff in his evidence stated that he has filed separate form number 7. He has not produced any documents, but in his own chief examination, he says that he has filed separate form number 7 respect of these properties.
All right, that is his statement. But what is the truth? Did he file form number 7?
He should have, because it's on statement.
He had filed form number 7.
Yes.
What is the law? all applications will be clubbed together.
Clubbed together.
That is not done.
He has not pursued or he has not challenged my order.
No, that is not done.
Yes.
All applications are not clubbed together.
Yes.
The inference is his statement that he has filed form number 7 is wrong.
Wrong andre.
See, if I make a
If
statement,
advantages to him, it may be wrong.
if I make a statement that I have built Qutub Minar,
Yes.
then it be stated as an admission that I have built Qutub Minar.
In this circumstance,
It can be ascertained. It can be ascertained who built Qutub Minar, me or someone else.
when he himself says that he has filed Form 7, why it should be discredited is the. He voluntarily said it is not in cross-examination, it's in chief examiner.
All right. Merely because a statement is made, it can't be treated as an admission. Admission can be explained. So if the form number 7 is filed, the law contemplates that all form number 7 applications, in respect of a particular 7 number, have to be clubbed together and decided by common order. What you are saying is, by common order, two applications are considered. So if the
third application
application by the plaintiff is not considered, the court will presume that no such application is filed. Statement is wrong.
Or it can be.
We can show that form number 7 application is indeed filed and it was rejected.
Or it can be the first, the plaintiff did not pursue the application, or did he challenge my order?
You can produce that order. Did you produce that order?
I did not. I stated that his statement. He voluntarily stated it is not in cross-examination. So that is the contention of third defendant.
When this number 7 was filed, where all these brothers were staying together.
They were not staying together. Lord, first the plaintiff has been granted with some other land, admittedly. It's a Darkas land, not under the land tribunal. He was staying there. The first defendant was staying in B schedule property. The third defendant was staying in A schedule property.
How much land is granted to the plaintiff?
Plaintiff, Lord, it's under Darkas land.
What does it mean?
It's not under land tribunal grant.
No. What does it mean?
Under the land grant rules.
All right. How much land is granted?
That is not stated by extent is not stated. But he is stated that he is granted with the Darkas land.
Extent he has not stated. He could have stated.
The defendant ಹೇಳಿಲ್ಲ, extent ಹೇಳಿಲ್ಲ. Extent ಹೇಳಿಲ್ಲ. And the first defendant before the land tribunal consented for grant of A schedule property in favor of the third defendant, and said that B schedule property may be granted to him. So now the trial court mainly proceeds to decree the suit on the ground that a suggestion is made to the plaintiff in the cross-examination that father had long back surrendered the tenancy. Thereafter, the third defendant has acquired the tenancy under individual right. This is an indirect admission of the tenancy of the father. Therefore, we have to presume that it is the tenancy of the father. That is the main finding of the trial.
Father has acknowledged.
Suggestion was made to PW1, the cross-examination by third defendant, that father had long back surrendered the tenancy, and thereafter third defendant has assumed individual tenancy.
So you are admitting the fact that at one point of time,
At one point of time, father was
surrender is not established.
Surrender is not established at the head condo. So there is an admission of the fact that the father is, therefore, it is not an admission of the continuance of the tenancy by the father, or that subsequent continuance by the family.
Forget about all those things. Do you admit that at one point of time the father was tenant?
It has been stated in the cross, Lord, I cannot deny that.
No.
Yes.
Even in the cross-examination, party can make a wrong admission, wrong statement. Doesn't mean that the statement has to be accepted. Even the admission can be explained. Explained and shown to be wrong.
Shown to be wrong. And admission should be direct, and
that is understood.
Indirect cannot be an admission.
Admission can be shown to be wrong. Now I'm putting a question to you. What are your instructions? Do you admit that at one point of time the property was held by his father?
No, it is not admitted anywhere except a suggestion.
Forget about admission.
No, we don't admit.
Forget about admission. Do you say that it was father's property at one point of time?
No. No. The written statement also has not stated. In the
I'm not on written statement. I'm on real truth.
Illa. real truth, but as I could cross-examine myself with the party and get elicit the facts. Even today they are in possession and they are cultivating. And at that point of time of grant, there was no dispute between the family members. Subsequently, certain misunderstanding.
Did you establish a separate residence when this form number 7 was filed?
Yes, I can make out, point out from the evidence.
So only based on the suggestion the suit is decreed?
Mainly based on the suggestion the suit is decreed and burden is placed upon the third defendant to prove that it is individual grant, rather than whether the burden
is on the plaintiff. Yes. Now what substantial question of law you have?
Substantial question of law, my lord, I have treated is whether first para 17 in my appeal memo, whether the courts are justified in holding that real properties or joint family properties, holding without there being any material or record, and on wrong assumption of indirect admission by the third defendant. The other one is whether the court will be justified in placing the entire burden upon the third defendant to the properties as absolute properties by ignoring issue number 1, framed placing burden upon the plaintiff. Whether the appreciation of oral and documentary evidence are perverse and arbitrary. The additional issue number 1, that is, Lord, I had in my written statement pleaded that there are other properties of mother from her maternal side that has not been included in the. So
mother was not alive?
Mother was at that point of alive, but now it appears that those properties have been taken away by the parents by filing Form 7.
So when the mother was alive, how that property can?
I may not stress much on that. Then, my lord, whether the court will have committed an error relying upon Exhibit D1, but the author of the said document is not examined and the contents of same are contrary to the pleading. Exhibit D1 is the first defendant who has been granted with 65 cents of land places a document called Chalageni cheat to contend that he was the tenant of the entire extent, A and B schedule.
Entire extent,
A and B schedule. Non-tenant in there. That is not his pleading.
What is the document?
That document is Chalageni cheat. Geni cheat. So adannu kuda rely upon ಮಾಡ್ತಾರೆ because it is contrary to the very own pleading of first defendant. So therefore, that also I have not wrong appreciation of documents, wrong appreciation of oral
Just a
evidence.
second. See, as far as grant is concerned, the law is well settled. The court would start with a presumption that the property belongs to the person to whom the land is granted. If somebody intends to contend otherwise, the burden is on him. So you wanted to contend, though the property was granted in the name of the first defendant, it is a joint family property. The burden was on you. How the issue can be framed casting the burden on the first defendant?
That may not be correct. The issue is framed rightly, my lord, but while appreciating.
So it's rightly framed, huh?
Rightly framed.
Casting burden on?
Plaintiff. Plaintiff. But while finding, third defendant has not proved,
Here, the substantial question of law which my learned friend has framed, my lord would kindly turn to page 176 of the paper. These are not the questions that has been raised even now. Please see the questions. I don't know how.
176?
Page 176 of the paper. Paper book hakidan, my learned friend.
Same, 70.
Read page number 9 in the appeal memo.
That the courts will are justified in holding that the plaintiffs have easementary right of prescription and necessity.
Paper book pidi adu cut and paste agide alli.
Adha question
appeal memo nodi. Appeal memo nodi.
Sorry,
maybe some cut and paste error agirbodu. These things are not uncommon.
I'm sorry, page 176.
No, probably by referring to this substantial question of law,
that's the reason.
you made a submission.
Yes, I'm sorry,
Come to page number 9.
Page 176 paper.
I'm surprised.
You'll ignore. Ide case in the paper book. Read page number 9.
Sir, I have not got it. Can I give?
Sorry?
So far as admissions is concerned, I leave it to court.
No, you understand the position of lies like this.
Yes, ma'am, that's what I said.
When it comes to government land,
It was our plaintiff's duty to establish that it's a joint family. That we have to establish.
no, if you are in a position to say, based on evidence, that it is established, then I will dismiss this appeal. I will not admit it. You can refer to that evidence.
2 days, the 3 days time. Maybe.
You are in a position to say, this property was tenanted property in the hands of father.
So your Rashma have to choose them and just go through that and make this.
The request
Only
of-
on that issue.
request of learned counsel for the respondent is this matter on Tuesday. Appellant is permitted to make necessary changes in the error pointed in the paperwork.
I'm extremely sorry for that.
Maybe there is a good substantial question of in some other case which we don't know.
That is.
I owe an apology. It's my.
No, that's
Also,
These things happen. As a lawyer, I have committed so many mistakes of this nature. I was known for that.
Experience. Good. Choose them.
And also see if there is any possibility of settlement. At the end of the day, it's put between the family members. Sorry, sir, I don't know I'm not familiar with the names of the advocates, senior advocates here in Bangalore. Your name? Because I didn't practice in Bangalore. That is the reason. Yes. Also.
But I submit something, but there are two connected matters. Only in this appeal, the first matter, the LCR is not called for. The last may kindly call for the LCR, let all the three appeals can be disposed of together. One is a suit for declaration. First, the appeal is the suit, it's a suit for declaration, the connected matters for hearing.
Final hearing?
No, it's for admission only. It's a plaintiff suit for declaration. Both the concurrent findings of both the trial court.
For appellant.
And for the respondent.
Madi. Also. Trial court has to come from which court? Records. Huh? R1A. So R1A died. Notice ಹೋಗಬೇಕಲ್ಲ ಅವರಿಗೆ. Issue notice on. I number 1 of 15, 2 of 15. Allah, ಬೇರೆ ಇದೆ. Who is dead now?
Satyanarayan Shetty.
Respond number?
But in appeal number 714, he is the first respondent.
Here, issue notice on I number 1 of 14 to the proposed legal deputies of respond number 1. In the meantime, registered to secure trial court records.
RSA 714.
Hearings for R1, Lord. Can you send us a letter? Can you pass it?
Also.
Appear for the respondent, my lords.
Password.
It's a possibility of settlement. It's taking some more time because they are giving some other options also.
Which matter?
36 corruption. That is whether adoption date is valid. Supreme Court remanded. Where
is the possibility?
Possibility is there, my lord. We have monetary wise some differences are there. Few more days, my lord. Either Tuesday or Wednesday.
The request of Learned Counsel for the appellant submits that there is a likelihood of a settlement. This matter on tenth. Loknath.
Hearing whether of the arguments matter. To VC, right?
VC. ಸೆಟ್ಲ್ ಆಗಿಲ್ವಾ? ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿಲ್ವಾ? ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿಲ್ವಾ?
I had suggested my parties they are agree for accepting the market rate of the price, not the property, whatever it is. I had suggested to them, but other side they had called me on Monday, last Monday, to visit the spot on Wednesday. Since I was having some festival activities, I said that we will visit the spot on Saturday. Thereafter, I called them peacefully, but there was no. They did not pick up my call.
So, what are your instructions from Mr. Varadaraj?
Parties is also present. I had asked my parties also to come. Back.
Likelihood of settlement or what?
I suggested, but my parties had not stated whether to, they are agreed or not. Mediation ಏನಾದರೂ ಟ್ರೈ ಮಾಡೋಣ ಅಂತ ನಾನು ಅದರ್ ಸೈಡ್ ಹೇಳಿದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೋಗಿ ಸ್ಪಾಟ್ ನೋಡ್ಬಿಟ್ಟು ಮೆಜರ್ಮೆಂಟ್ ಎಲ್ಲ ಮಾಡೋಣ. ಟೈಮ್ ಕೇಳಿ ಹೇಳ್ತೀನಿ. ಬೇರೆ ಪ್ರಪೋಸಲ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Madam wanted to visit this spot and she says she called you. There was no response from your end.
ನಾನೇ ಫೋನ್ ಮಾಡಿದ್ದೆ.
Your client is present. Where is he? Get him. Nim client idara?
ಏನೆಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಂಗಿದ್ರೆ ಅಮೌಂಟ್ ಸಜೆಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಅದನ್ನ ಹೇಳು.
Who wants to purchase?
ನಾವು ಪರ್ಚೇಸ್.
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡ್ತೀರಾ? ನೀವು ಅವರಿಗೆ ಕೊಡೋಕೆ ರೆಡಿ ಇದ್ದೀರಾ? So you want to purchase which property? Property in your possession or in their possession? Or possession purchase ಮಾಡ್ತೀರಾ?
ಪ್ರಪೋಸಲ್ ಕೊಡ್ತಾರೆ.
ಯಜಮಾನ್ರೆ ರಾಜಿ ಮಾಡ್ಕೊಳಕ್ ರೆಡಿ ಇದ್ದೀರಾ? ರೆಡಿ ಇದ್ದೀರಾ? ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ?
ಪ್ರಪೋಸಲ್ ಎಷ್ಟು ಏನು ಅಂತ ಹೇಳಿದ್ರೆ ಅದನ್ನ
Counsel for the whether your party is whether your party is willing to sell the property.
Yes.
Learned Counsel for the appellant and respondent would submit that. ರಿಪೇರಿ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಮೇಡಮ್. ರಿಪೇರಿ. They are carrying out some repairs. I think they are carrying out some repairs. There is some
ಕೆಳಗಡೆ ಇವ್ರ ಪೋರ್ಷನ್ ಇದೆ, ಅದ ನಮ್ಮ ಪಾರ್ಟ್ ಇದು. ಮೇಲ್ಗಡೆ ಮಾತ್ರ ಪೋರ್ಷನ್ ಕಾಮನ್ ಪ್ಯಾಸೇಜ್ ಇತ್ತು, ಅದಕ್ಕೆ ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾರೆ. ಅಲ್ಲ ನಮ್ಮ ಪಾರ್ಟಿ ಇಲ್ಲೇ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ, ಬೇರೆ ಫೋಟೋ.
ಯಜಮಾನ್ರೆ ಒಂದು ನಿಮಿಷ, ರಾಜೀವ್ ಮಾತುಕತೆ ನಡೀತಾ ಇದೆ ಅಲ್ವಾ? ಒಂದು ವಾರ ಸ್ವಲ್ಪ ಸುಮ್ಮನಿರಿ.
ಅಲ್ಲ ವರ್ಕೇ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
Donate for the appellant and respondent would submit that the proposal for settlement is still being considered by respective parties, and they seek a short accommodation. Justice Metron. ಸೊಳಗೆ ನೋಡಿ. The difficulty with this case is, unless you visit the spot and measure the property, you cannot understand the actual situation. Mandate resignation decree ಆಯ್ತಾ? Mandate resignation decree ಆಯ್ತಾ? Just a second, where is genealogy? All right. All right. Just a second. Suit for partition, huh? Filed by whom? Against her son.
There was a joint family. Basama husband died.
No.
The death of the husband, Basama put in a suit for partition.
Against whom? Husband's brother. Onu Basapana, Hanumantappa. See, Basama, wife of late Basappa antide.
Basappa and Hanumantappa are brothers.
Who is Shivama? Basama. Property belong to whom? Admitted fact. So Hanumantappa had half share, Basappa had half share. When Basappa died? 1979. And he had one wife and one daughter. All right. Now, what is the defense taken by Hanumantappa in the suit for partition?
He had led an unjust life. Therefore, he is not entitled to share in the land family property.
Oh, that was.
This is the ground on that they start for this. Our trial court has granted the decree respect of 1/4 share instead of half share claim to the person. Because Shivamma was arrayed as dependent in this court. Shivamma did not file any written statement or seeking not share the property. Trial court has granted 1/4 share. That was challenged by Hanumantappa, the regular appeal. The appellate court has reversed the finding to the trial court. They said that unjustity is a ground for rejection of denial of the share. That was challenged before the Supreme Court in the earlier RSA, but 384 of 1990. But the Supreme Court remanded the matter for consideration. A specific observation that the first appellate court has to consider whether the unjustity is a ground for disqualifying the person from seeking partition with the joint family property. That was the specific question which has been.
It is not answered. It is not answered.
Answered by the first appellate court. Now, first appellate court again says the unjustity is a ground for is a disqualification.
That is answered.
It is answered in the sense which is not supported by any provisions of law. The Succession Act does disqualify an unjustful wife from seeking partition of the husband's property. But now, against which not the last time kindly see the some law practice in a narrow compass that whether the wife of a predeceased co-person of a joint family is qualified from inheriting the share of husband in the joint family on the ground of leading in an unjust and immoral life. It's the question of law. But this question is no longer a secret. There are several judicial pronouncement says that the unjustity is not a ground for rejection of the government. I cannot not able to do any judgment of the Honorable Supreme Court. However, there are judgment of not the one judgment is of Pradesh High Court, another is by Calcutta High Court, Chhattisgarh, and one judgment of the Honorable Division Bench of Madras. All the judgments.
Now, on what basis the first appellate court said that the unjustity is a ground for rejecting the claim for partition?
Based upon the judgment of the Honorable Supreme Court, it is in relation to a remarriage. That was the case of remarriage after the death of the husband. That judgment has no application to the facts of the present case. That is not a case of leading unjust life and continue to remain as a widow of the deceased. Here there is no remarriage.
You are for plaintiff.
Now Basama is no more blood. Only Shivamma blood is contesting as that.
He is entitled to opt.
Trial court has granted only 1/4 share to her mother.
But they have not filed any appeal against that.
What is your ground now?
And they have not produced any document to prove the marriage was solemn. Marriage itself is denied by the defendant. Marriage itself is denied by the defendant.
You say that appellant is not wife of Basappa?
Yes, my lord. And also the first defendant, the second defendant, Shivamma, is also not daughter of the Basappa, my lord.
Who according to is the wife of Basappa?
Basappa is not having any
Was unmarried.
marriage. He was not taken any marriage.
Sorry to interrupt us. Basappa that has filed a petition for divorce in 1958. Therefore, this argument
My lord.
What happened to
Before that, my lord, they have filed.
That's holding that no grounds are made out for divorce. And thereafter.
No, my lord, that has been dismissed for default.
There is one more petition filed thereafter.
Miscellaneous petition.
Our
That is the matter. My lord, and moreover, my lord, the daughter of Basamma and Shivamma had filed a maintenance petition against the Basappa, my lord. That has been maintenance was granted to the daughter, but not granted to the wife, my lord. Stating the same, she has not taken marriage with the Basappa, my lord. And only at that ground it has been that has been not challenged by the wife. That is not challenged by the wife, my lord. So that, my lord, that is understood that, my lord, there was no marriage was taken.
Now you admit that daughter is there.
Daughter, my lord, there was maybe illicit relationship, my lord. There was, and moreover, my lord, she has not produced any document. Marriage was taken place or not, and witnesses, no one witnesses are examined on behalf of the plaintiff to prove the marriage.
When their marriage took place, according to them.
Marriage date was not mentioned, my lord.
So when this petition for divorce was filed?
Year 19, marriage took place not on 29/3/1949. But the petition for divorce.
No documents was.
Petition for divorce was filed. And that is miscellaneous petition number 58 of 58. It was dismissed for non-prosecution on 24/6.
Do you have got the copy of the petition? No, both the courts are given a finding that Basappa was married.
Yes,
That is the finding.
there is one more petition filed there afterwards. Fresh miscellaneous petition number 136 of 1958 for similar prayer, which has been dismissed, considered on merits and dismissed on 12/11/1959. And thereafter, in 1964, a petition for a suit for maintenance has been filed by both mother and daughter. That has been dismissed by the only insofar as daughter, the maintenance was granted by the trial court.
Against wife, why it is dismissed?
Against wife, the dismissal on the ground that she left the husband
not on the ground that she is not the wife.
No, not on the ground that she is not.
When you said the criminal miscellaneous petition seeking maintenance, there's a finding that Basamma was not married to Basappa. You made a submission.
In the judgment itself is the appellate court judgment.
You made a submission. The petition seeking maintenance is dismissed on the premise that Basamma has not married Basappa. On what basis you made this submission?
That appellate court judgment, my lord. I am.
Read that portion of the judgment.
There are 10, my lord. Paper book, page number 66, my lord. Start from para 10, my lord.
Paper book.
Paper book.
Page number 66 is the decree. So where the appellate court said marriage has not taken place.
Earlier judgment.
No, earlier judgment is set aside.
Earlier, yes, that is set aside and remanded.
You can't rely on the earlier judgment. That is set aside. Matter is remanded. So don't rely on the earlier judgment. Whether in the present judgment, which is under challenge, is there any finding?
This matter is counsel and record is not well. This matter is entrusted to me.
So
Monday, my lord, kindly have done Monday, my lord. I will took some documents from the other side, my lord.
Who is the council on record?
It's not.
He submitted that council for the respondent is not keeping well. Justice met on Monday for further reading. You should have told it in the beginning. See, there is no finding that Basamma is not the wife. There is no such finding.
I will read
The court says Basamma is the wife, but declined.
She had a relationship.
Declined to grant share on the ground that on the ground of unjustity.
It's fine.
You share the judgment with him.
School for petition for divorce. March as exhibit D1. Record marriage is there. I find out for us.
Yes.
Very matters. So wait matter. Respecting my father's will. There are two attesting witnesses.
You have been examined?
David has been signed, but there's the order of the honorable court where they have to be examined before the central project coordinator and the rest. That has not happened.
Is this matter before the central project coordinator to record the evidence of attesting witnesses, the will for which the probate is sought?
The project coordinator along with the registrar has for recording the evidence.
Whoever is permitted to record, yes, authorized to record, then they will record. Is this matter on? Which date you want? Witnesses have to come. You can choose the date of your convenience.
Friday, my lord.
Is this matter on? 10th Friday, na? 11th. Holiday. 18th. Report 47. ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ ಅವರು ರಿಟೈರ್ ಆಗಿದ್ದಾರೆ ಅಭಿನಯ್ ವೈಟ್ ಅಂತ 282 B2C ಮಾತ್ರ ಅನ್ನೋದು ಅಪಲೆಂಟ್ಗೆ ಹೋಗಿದ್ದ ಅಪಲೆಂಟ್ ನಂಬರ್ 1 to 4 ಅಂತ ಹೋಗಿತ್ತು 1 and 4 1 and 4 ನೋಟಿಸ್ ಹೋಗಿತ್ತು ಹೆಸರು ಹಾಕಿಲ್ವಲ್ಲ ಸೂಟೇನು There is no representation for the appellants. This appeal is of the year 2006. Last time last time mistake. Even on 28/10/2022, then appeared. Is this matter? On 14th is the last chance. Huh? Huh? Very good. Gottara? Password. Who appears for the appellant? One.
I have also prepared some.
Wait. Yes.
That 92nd appeal, filed a suit against the defendant for mandate declaration and also mandate injunction in respect of 23 meters of land. That is B scheduled property. A scheduled property is the owner of 1 acre and odd land, 1 acre 10 meters of land. This is the only land which he has.
Is it mandatory injunction or possession?
Possession. Possession, declaration and possession. Possession. Well, at the basis for filing of this suit is Melan under a oral party, I'm sorry, Palupatti. Melan, 1 acre 10 guntas of land. That is Melan, this scheduled property was allotted to the appellant share in the family party. Then Melan, ever since they have been just giving you the Melan.
When this partition took place?
Melan, this partition took place on 14/10.
1984.
1984, Melan. They seem to a scheduled property, which is inclusive of B scheduled property was allotted to this area. Then Melan, he was cultivating this land because of his poverty in Bangalore and such a job. He stayed back in Bangalore for 1 year, and then when he went back, Melan, it was found that the defendant has encroached 23 meters of land. Then Melan, on the southern side of the survey number, defendant is the artistic owner of.
When you say he's encroached, did he put up any structure or just he put the fence?
No structure, Melan. No structure.
Yes.
Then Melan, legal notice was issued, calling upon him to Melan vacate the area. After the legal receipt of the legal notice, Melan, he It's a borewell on that property belonging to the enclosed area. It's a borewell. And my lord, thereafter, the suit was filed for declaration and possession. Well, the trial court, well, had partly decreed the suit, holding that so far as declaration is concerned, you are not entitled because this is not a registered party. However, you are the co-owner of the joint family property, you are entitled to this. And eventually, well, suit was partly decreed for possession of 23 guntas of enclosed portion where by the defendant. Well,
How the decree for possession was granted when the court says that the partition has not taken place?
So far as possession is concerned, my lord, only to the extent of, my lord, for possession.
Joint possession. Joint possession or what?
Land possession.
Joint possession.
Joint possession. Plaintiffs, not the defendant.
Understood. The court says declaration can't be granted because partition deed is not registered. That means the court says the properties are joint.
They are in joint owners.
All right. So then, whether the decree for possession was for joint possession or exclusive possession?
The exclusive possession of the plaintiff.
How that is permissible?
No, I'm sorry, not exclusive. Because my lord, when the court says the joint possession, then my lord, obviously it is for possession on behalf of the joint family.
That's what the court
Yes,
was.
yes, please do. Yes.
All right, understood.
Well, this suit was decreed.
Partly decreed.
Partly decreed. The contention of the suit, commissioner was appointed. Commissioner report was submitted after 1 to notice to the parties. And found out there is an encroachment of 23 guntas of land. Well, on the southern side of the plaintiffs and on the northern side of his case. Well, in the written statement filed by the defendant, well, he contended that
Those possession.
the trial court so far as adverse position is concerned.
Negative.
And my lord, the appeal filed by the defendant challenging that portion of the appeal was allowed. Holding the suit is barred by limitation.
All right, you did not file appeal?
I, so far as the other
Declaration is.
Is that my lord has been questioned?
No, what you are saying is Article 65 governs.
Please, my lord.
Unless the adverse position is established, the suit for possession based on title can't be dismissed. So his defense, no, his defense only on adverse possession.
Adverse possession, and my lord, he suppresses the material bank that his father, that is my lord, originally this was filed against the respondent's father. Well, he files a parallel number 7 in respect of this 28 meters of land for the land tribunal saying that is the tenant, this is the enclosed portion. Then the land tribunal rejects the application and he acquits. Well, and on these admitted evidence, court said that we are not perfected.
All right.
So far as the ground of limitation, absolutely it is not.
Yes. Now take to the finding of the first appellate.
Please, I kindly come to page 21. Reason shall I?
Only that portion which says the suit is barred by limitation.
Yes. My lord, kindly. Only that portion, my lord, I will take to your last. Barred by limitation. Yes. So last time I kindly come to para 28 and page, my lord, 19. Page 31. That portion, relevant portion I am taking your last 31 minutes. 31 page. May I read from para 28 minutes and the left side bottom. 30. In the written statement, defendant has specifically taken contention that from the ancestors, he has been in actual possession and enjoyment of portion situated beyond road towards the other side. The possession of the defendant to said area is admitted. But it is the specific case of the plaintiff that in the year 1990, he has come in possession of the same by encroaching the same, but the same.
I read it.
From going through exhibit B1 and other Pani extracts produced by the plaintiff.
Yes. Read it.
Absolutely. regarding limitation is not part.
Did you admit the partition?
It itself has produced.
Exhibit D1 is the partition.
You admitted partition.
How the actually about each side set that first defense chapter. It's a pervasive. That's the case is the mind changing. Mind changing. We amended. All land allotted to the share South Independence land is number 38 and 59. Station. Next station. The portion where it is not written. Encroachment made by the Independence as the triangular regular shape is also recently constructed the irrigation well very known as East Independence wetline number 8, west survey number 44, south Independence wetland 58, north remaining wetline number 97. This is the boundaries in which he has published the line. First, now that's the come to
just a second. Exhibit
D1. Implementation of the southern boundary. The irrigation of encroachment comes to the southern side of the number 27. What is the date? Because exhibit D1 the partition is the Dhanama.
Exhibit D1.
D1. But he admits the execution of this partition D. Since it is unregistered and unstamped,
Not admitted.
But it marked the process of D1.
But court has refused. Exhibit.
So I have a point of boundary. I have a point. What's in the boxes I have dated. It's like his father Chuttaya Gowda and his uncle Bommaya Gowda constituted right. Survey number 37 consists of 10 acres, 36. Total extent of 10 acres, 36. Out of which 34 hectares. Yes, out of 10 acres, 36 hectares, 34 hectares is a Kharab land. Survey number 37. 7 acres, 2 hectares had fallen to the share of Kuttailo. 3 acres had fallen to the land of Karnataka. But this 7 acre 2 hectares, they have partitioned the property and 14 and 19.
What about excluding Kharab? Both are allotted excluding Kharab.
Yes, excluding Kharab. And because 7 acre 2 hectares were there,
Correct.
so 10 acre
7 acre 2 guntas of land, they have divided by 1/6 90 share 1 acre 10 guntas. So they permitted to read.
20 share 7 acre 2 guntas alva.
Right is father.
All right.
90 father Puttaya owner.
All right. All right. Understood. 1 acre 10 gunta.
1 acre 10 guntas. So that is Asian property.
So that is in which year? 1984. ನಿಮ್ಮದು ಟೈಪ್ ಕಾಪಿ ಇದೆಯಾ? ಎಕ್ಸಿಬಿಟ್ D1 ಇದಲ್ವಾ? ಅದು ಬಿಟ್ಬಿಡಿ, ಆ ಪ್ರಿಯಾಂಬಲ್ ಬಿಟ್ಬಿಡಿ, ರಿಲೆವೆಂಟ್ ಪೋರ್ಷನ್ ಬನ್ನಿ.
ಕೃಷ್ಣಮೂರ್ತಿ ಮಳಲಿ ಗ್ರಾಮದ ಸಭೆಯಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆಯಲ್ಲಿ ಬರುತ್ತೆ. ಉತ್ತರ ಚಕ್ರವರ್ತಿ ಪೂರ್ವಕ್ಕೆ ಸರ್ಕಾರಿ ಗುಡ್ಡ ಡ್ಯಾಮ್, ದಕ್ಷಿಣ 2ನೇ ಇಸ್ತೆಗಾರ ನಾಗರಾಜ ತಳಿ ಬಂದಿದೆ. 2ನೇ ಇಸ್ತೆಗಾರ ನಾಗರಾಜ ಎಂಬುವರಿಗೆ ಇದೇ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 37ರಲ್ಲಿ 1 ಎಕರೆ 10 ಗುಂಟೆಯಲ್ಲಿ ಬರುತ್ತೆ. ಉತ್ತರ ಚಕ್ರವರ್ತಿ ಪೂರ್ವ ಸರ್ಕಾರಿ ಡ್ಯಾಮ್, ಪಶ್ಚಿಮ ತಂದೆ ಪುಟ್ಟಯ್ಯ ಗೌಡರ ಬಾಗಾಯಿತು. ಉತ್ತರ 1ನೇ ಇಸ್ತೆಗಾರ ಕೃಷ್ಣಮೂರ್ತಿ ಅವರ ತಳಿ. ದಕ್ಷಿಣಕ್ಕೆ PWD ರಸ್ತೆಗೆ ಬಿಟ್ಟು ಇದೇ ಇಟ್ಟ ಇದೇ ಸರ್ವೆ ನಂಬರಿನ ಜಾಗ ಮತ್ತು ಚಿನ್ನಪ್ಪ ಗೌಡರ ಕಾಲದ ಸರ್ವೆ ನಂಬರ್ 39
ಯಾರು plaintiff? What is the name of the plaintiff? Nagaraja. So what you are saying is Nagaraj is allotted property which is bounded on the southern side by the road.
Also examined engineer from department.
So in between the property of the plaintiff and defendant, there is road.
That is suppressed by the entire time to exist in the whole not disclosed. Therefore, words are specifically identified line shading problem. Line shading is the again for more than the more but this is complete disrespect of the property.
Okay.
That's the way you see next then I will take it also to exhibit D2. One more portion exhibit D1. 45 is 11 portion from 15 lines from the top. Allade they most to
Same page.
next page. Allade they most to ಎರಡನೇ ಇಸ್ತೆಗಾರ ನಾಗರಾಜ ಪಕ್ಕದಲ್ಲಿ PWD ರಸ್ತೆಗೆ ಪುಟ್ಟಯ್ಯ ಗೌಡರ ಅಣ್ಣ ಧರ್ಮಯ್ಯ ಗೌಡರ ಈಗಾಗಲೇ 9 ಗುಂಟೆಗಳನ್ನು
ಅಲ್ಲದೆ 37ನೇ ಇಸೆ ನಂಬರ್ ಅಲ್ಲಿ 2ನೇ ಇಸ್ತೆ ನಾಗರಾಜ್ ಎಂಬುವರ ಇಸಿಗೆ ಬಿಟ್ಟ ತಕ್ಕ ಜಮೀನಿನ ಪಕ್ಕದಲ್ಲಿ PWD ರಸ್ತೆಗೆಂದು ಪುಟ್ಟಯ್ಯ
ಗೌಡರ ಅಣ್ಣ ಧರ್ಮಯ್ಯ ಗೌಡರ ಖಾತೆ ಮತ್ತು ಕಾಣಿಗೆ ಇದ್ದಾಗಲೇ 1974 ಕಾಣಿಗೆ ಈಗಾಗಲೇ 9 ಗುಂಟೆಗಳನ್ನು ಬಿಟ್ಟಿದೆ. Therefore, 9 acres of land has been left for road. Here of the words, I specifically specifically contained in the written statement also.
Now, just a second. A commissioner is appointed. He identifies the road.
He identifies the road, but he inconsistent evidence. It is evidence for the road, he says Kalvari. But in the report, he says
Whatever it is, the width is mentioned as 9 feet. 9 guntas. Then, now where is the report of the commissioner? So the portion of the property which he has identified as the encroachment falls to the south of the road. So what you are saying is property to the south of the road is not allotted to him.
not instructed at all. In the written statement also notes I took up a contention towards the right side of the road. He is not the owner and he is not in possession of any bit of land.
Towards the south.
Towards the right side of the road, towards the side south corner, towards the south only.
But there is nothing called as right side. If you start from that side, it becomes north becomes the right. If you start from the western side.
I said that the road runs from south to north and this east to west.
East to west is there.
Property towards the eastern side.
The road runs from east to west.
Towards the yes.
But there is nothing called as right and left. When you say it is on the right side, you must also state on which direction you are coming. So let us take it. Let us take it as south. South of the road.
From this side it is south. Only from the road.
From any side it is south. From any side, south is south. It can be right or left depending upon on which side you are facing. If you are facing on the towards east, then it is on the right side. If you are facing towards west, then it is on the left side. What is another?
So he is not owning any bit of land and he is not in possession of any bit of land. That's why it's a
Now, just a second. Whether this objection is filed to this report, the cross-examine the commissioner. Cross-examine. What does he say?
Commissioner he road ಅಳತೆ ಮಾಡಿಲ್ಲ. Commissioner cross-examine road ಅಳತೆ ಮಾಡಿಲ್ಲ. ಖರಾಬ್ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತಕ್ಕಂಥದ್ದು ಏನು ಹೇಳಿ. ಖರಾಬ್ 2 ಗುಂಟೆ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಆಮೇಲೆ 37 ಮಾಡಿ ಮಾಡಿದೆ ಅಂತ 38 ಅಳತೆ ಮಾಡಿ.
All right.
On what basis you are seeking report?
Right. In the case of the plaintiff.
Just a second. You admit partition of 1984.
Yes.
And according to you, that was reduced into writing. That is marked exhibit D1. You are not disputing that. According to that exhibit D1, your property is bounded on the southern side by the road.
This road, once my land, beyond that road also, towards southern side, my property is there.
How do you say that? How do you say that? No.
Southern
So,
side.
all right.
Finding of the learned judge.
Not the finding. You have to establish from the document that is partition deed that you have got property on either side of the road.
Yes. On either side of the road, I have got the property.
That is to be established based on the partition agreement.
Yes. The evidence is the file number 7 filed by the defendant before the land tribunal claiming this portion of the land for occupancy rights. Yeah, clearly that file number 7 is also produced.
Forget of form number 7. You claim this property is allotted to you in a partition. And according to you, this partition was reduced into writing. In that partition, you must show that you had property or you are allotted property on either side of the road.
Either side of the road. Well, may I take
The recital in the partition deed, which learned advocate for respondent read out, gives an impression that your property towards southern side ends up to the road or runs up to the road. To the south of road, property is not allotted to you.
take the evidence.
Your property is to the north.
My lord, I take the evidence of defendant himself in the class examination. Kindly take. They do not dispute regarding the encroachment. They admit that we are the owner of this property. The class examination. Take your class.
There is one more point. You have raised the defense of adverse possession.
Again, with reference to that towards the eastern side of the ward, that he was not in possession at all. It is a
So you admit that the 1 acre 10 gunta is allotted? But to understand the facts of the case, there is no dispute that he has been allotted 1 acre 10 gunta. We'll measure the property once again. No, what you say is the report is incorrect. You said Karab is not identified. You say that the commissioner has not measured the extent of property used for the road or pathway, whatever. Let there be a fresh measurement. Give him 1 acre 10 guntas. Forget about all these technicalities.
I have no objection.
1 acre 10 gunta, maybe entitled towards the Krishnamurti share on the other side.
No.
Once the boundary is being identified as per exhibit B1, that for Nagarajan is the Jaga Pakka Raste and the person himself and the process of the Nagarajan. Who they will witness an examiner, who they will Raste again. Raste will be engineer examiner to Raste. Raste Pakka that is very, that is what you are specifically I lay out. My specific case on exhibit B1, not there exhibit B1, who makes that he gets a right.
See, question is whether he is allotted 1 acre 10 guntas or in the partition, has he not been allotted 1 acre 10 guntas? Should he not get 1 acre 10 guntas? So point to be seen is whether survey number 38 commences from the boundary of the road which is said to have been recognized in the partition agreement. Exhibit? See, where is the original sketch pertaining to survey number 37? So you are having in survey number 38, not in 37. No. In survey number 37, whether you have been allotted any share, then in his case is he has been allotted 1 acre 23 guntas in survey number 10 guntas in survey number 37. All right. See, all right. At the same time, it is also made specific that you are allotted property in survey number 38. So now we are claiming right in survey number 37. Agala. See, you are not allotted any share in property bearing survey number 37. See, let us forget about all those technicalities. When the properties were partitioned, the family members had a clear understanding that he should be given share in survey number 37. You should be given share in survey number 38. Whatever. Your family member alwa. So on what basis then you claim right in survey number 37? All right. You are in possession. You have to establish adverse possession. If the suit for possession based on title, if it is to be dismissed, it is only if the dependent is able to establish adverse possession, then the suit has to be dismissed. If you are saying that you are not the family member, then you can't say that he should not be given share in surrey number 37. Surrey number 37 belong. I thought that you are the family member. So you are not party to this agreement. Exhibit. Yes. So if you are not family member, if it is not your family property, then how you can claim right over surrey number 37? All right, understood. Your possession. All understood. Your possession is all right. Your case? See, it is not your property. It's not your family property. The property admittedly belongs to the family of the plaintiff. So their title is not in dispute. So the property according to them is allotted their share. Now, when the property, see, you can question allotment provided you are also having share in that particular survey number. You are not having share. All right, understood. You are in possession. There is no dispute at all. He has filed a suit for possession. Your possession is admitted. Now the question is whether that possession has become adverse or not. If it has become adverse, then his suit has to be dismissed. The prior possession is not his case that his case is based on prior possession. His case is that the property belongs to him. He is the owner of the property. So this is a case for possession based on title. What he is saying is, you are not sought for declaration. The trial court said that you are not the owner.
No. Trial court has said you are the co-owner, therefore suit is maintainable.
The trial court has declared the owner.
Yes, I presume that my suit is my land on behalf of the joint owners of the property.
Sorry? No, all right. You may find the word rejected, but if the court says that he is the co-owner along with other family members, then that is good as saying that he is the owner.
Certainly the finding of the trial court.
Read that finding.
Yes, please.
See, understood. Now let us say that you are in possession for 30 years, 50 years, 60 years, whatever. Now you have to establish adverse possession.
Para 15 of the trial court judgment, that is in page 54 of the trial court judgment. Second page is 17. Para 15, Para 15 of the trial court. Second page 17. That is page 54. Arrangement. Bottom and Para 15. Yes. The first list claimed by the plaintiff is declared that declaring as absolute owner of plain scheduled property. But as discussed above, when the partition Kahanama itself has no value in the eye of law, court has to consider that plain scheduled property still continues to be the joint family property of the plaintiff.
Yes.
As such, they have very
Yes, understood.
You can't question all those things. He admittedly, my lord, we are the owner. He admits we are the owner of survey number 37.
See, when you produce that partition deed, when you rely upon the partition, it is as good as saying that the survey number 37 belongs to them. It belongs to the family. Yes. All right. And what you are saying is the portion is not allotted to him. The court says the partition is not yet effected. In the sense, there is no value to the partition deed. that event the property belongs to that family jointly. Now it is for between them, whether to divide it again or do something else, it is for them. But as far as you are concerned, you have to establish ownership by adverse possession. If adverse possession is not established, you have to hand over possession. So what you are saying, no, just a second. If you are able to establish beyond that road on the southern side, survey number 37 does not exist, then I'll accept your contention. If you are saying that the survey number 37 ends up to the road and doesn't proceed further in survey number towards the southern side, then I'll accept your contention.
The question of sheep training in is only. They are dying.
That's what I'm asking. Are you in a position to establish that the road which is referred in the partition agreement is the boundary of survey number 37? To the south of survey number, to the said road, there is no survey number 37. Is it your case? Are you in a position to establish this? Wait, what you have said I have understood. What you are trying to say is allotted only up to the road, not beyond road and Himalaya. That submission is understood. That is what is coming from that exhibit D1 alado. D1. All right. All right. Understood. All right. All right. Now, if you are able to show that to the south of this road, survey number 37 doesn't exist, and I will accept your contention. That's the reason I'm asking, where is the original sketch? Commission report Allah. I'm not referring to the commission report. I'm referring to the sketch, original sketch, which gives the pictorial description of survey number 37 and 38. So is it your case when the commissioner was cross-examined? Is it your case that location of survey number 37 is wrongly shown in the sketch?
My lad, my response is sufficient to your lordship. When he claims my lad adverse possession, and when he goes before the land tribunal, claiming very same extent of the land, my lad, before the land, he doesn't claim 1 acre can be done. He claims only very same land, my lad, before the land tribunal, land occupancy rates. And my lad, adverse possession, my lad, in the length of my lad, these timings. But he can't know, my lad, contradict the version and say.
Please, I'm not preventing you from raising any contention. So do you feel that I have prevented you from raising any contention? ಇಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಯಾವ್ದು ಗೊತ್ತಿರಲ್ಲ thousands of judgments ಇರುತ್ತೆ ಯಾಕೆ ಗೊತ್ತಾಗುತ್ತೆ Yes. The position is very clear. The finding in a suit for declaration of shariah succeed only on the basis of full writing. That is done only by adducing sufficient evidence to start the order on it. Irrespective of the question whether the defendant is accused in the case or not. Here is a training set up by the defendant is all arrested. The options of establishment of the right of full writing. Now, when you file form number 7, in your form number 7, whom did you refer the as the owner? So this is the case where ownership is admitted. So when that was filed, form number 7?
During the pendency of the
Suit.
yes. Subject to
So 98 form number 7 was allowed or 78?
Form number 7 rejected by that.
No. Filing of form number 7, 7A. It's not 7, 7A.
7A.
So there is a cutoff date for filing form number 7.
That is after filing the suit.
It can't be form number 7.
No, A, form number 7A. Yes. I stand corrected, Mela.
Yes, sir.
The other code is also considered as a thing. Because the 7 of part number 7 is fine. Doesn't mean that the 90 was installed. And also when it is the investment of collection also. And there is no key in the fact that people have to the road. Options of any trading. It's not
All right. You want to take a shelter under a defense that there is no proper pleading that the road property exists, survey number 37 exists to the south of road. That is your specific case now, specific defense now. Now tell me on what basis you are entitled to continue in possession with that particular property, survey number 37. All right. All right. All right. If it is long possession, then continue to be in possession, provided the owner doesn't seek possession of the property from the encroacher. Right? Encroacher can defend the case for possession, provided if he is able to establish adverse possession. That is the law. Sir, are you not admitting the fact that the property belongs to the family of the plaintiffs?
Writing is before the court. You say when you plead before the court, 1 year can go down.
See, there can't be any equity in favor of an encroacher. If you have perfected adverse possession now, then that is the law that recognizes your right to continue in possession. If you are not perfected adverse possession, there is no evidence. Don't stand on technicalities. Or you can establish the fact that if you are in a position to say so, that to the south of survey number 37, to the south of the road, survey number 37 doesn't exist, this suit has to be dismissed. But the report says otherwise. Report says, even to the south of the road, the survey number 37 is in existence. Now, how do you say that report is incorrect?
What is incorrect? The commissioner, without referring to exhibit D, without referring to the title, suddenly he goes to the spot and
No, see, just a second. Commissioner is not bound by exhibit D1. Commissioner can say, based on the original records, where the survey number 37 ends on the southern side. That much power is there with the commissioner. That is his role. And if he says, based on the survey records, that survey number 37 extends to the southern portion of the road, then he is in a position to say this portion extends to the south of the road referred in partition D. He may also say that whether the plaintiff is in possession or defendant is in possession. He says that you are in possession. And that is your case also, that you are in possession of part of survey number 37. For the very property, you filed form number 7A. That has been rejected. Admittedly, now you are not the owner. Plea of adverse possession doesn't arise for the simple reason you filed form number 7A. This is all certain position of law, you know it better. So ultimately, you are occupying a property belonging to the plaintiff or maybe his family member, whatever. As an encroacher, you have enjoyed the property for so many years. I think now time has come to gracefully vacate the property.
The question of plaintiff's possession only has to do it. But once the plaintiff's possession, the extent of one letter has been bounded out. One specific case, after the boundary, not the owner, is not.
See, he can't be the owner provided it is not survey number 37. If it is
Maybe survey number 37, maybe to this extent, it must have encroached.
no, it's all right. You can say so. You can say so. In the sense, you can raise a contention that survey number 37 ends at a place where the road is shown, that you can substantiate by reducing evidence or by placing some records that the dimension or the shape of survey number 37 is not as per the report submitted by the court commissioner. It is something else. And this has to be established by placing necessary survey records. Have you produced it to show that this dimension or the shape shown by the court commissioner in this part of survey number 37 is contrary to the survey records? See, the best piece of evidence is you must get the original map showing the shape of survey number 37. If it is contrary to the report of the court commissioner, then you can say that the report of the court commissioner is erroneous. Or by some other evidence, you must establish that the southern boundary of survey number 37 ends at the edge of the road. If there is evidence to that effect, let us consider it. But it is not the case. What has happened is, you file form number 7A in respect of this property, which according to you is survey number 37, of which now you are not the owner. So, yen gota, he has enjoyed this property all these years. Now time has come. Whatever. The property, you are offering for settlement, it is indeed for that. I have no objection. I am not coming in there. So, at one point of time, your client should realize, now you have put in your best effort, the best possible argument that could be have been addressed in this case that you have addressed. All best possible argument you have addressed. See, even I was also with you when we read Exhibit D1. I carried the impression that you are also the family member. If you are a family member, if you are a party to that agreement, I would have said that the property has been allotted to you only up to the road, not beyond road. You are not the family member. You are the owner of survey number 38. And you have occupied survey number 37. You claim occupancy. Occupancy is rejected. In that application, you admit to his ownership. I heard you learn. I have given patient hearing. Third, the learned advocate appearing for the appellant, the learned advocate appearing for the respondent. When it comes for the respondent at this juncture, seeks a small accommodation to argue further. This matter on Monday for further hearing. See, yes, dug the borewell. Correct. Yes, dug the borewell.
Behind the road, admits.
Just a second. Yes, dug the borewell. And if he wants that particular property, if you are in a position to give that particular property, try to accommodate. All right. All right. In that event, at least give the cost of borewell. See, what has happened is, strictly, if you go by strict rule of law, you are also liable to pay the mean profit for so many years. 3 years prior to the filing of the suit, up to the date of whatever. See, there is nothing. Why do you hesitate to give the property when it is not your? See, no. If you say that the property is of no value and no consequence, and when you are aware that this property is not your property, you should gracefully hand it over the position. You have to bear one thing in mind. Don't know what will be the fate of this case. Appeal may be allowed, appeal may be dismissed. We don't know. Assuming that the appeal is allowed, again you have to file a case for execution. You seek possession. can avoid all those things, can make some reasonable offer. No, reasonable offer, so that he is also ready to hand over some possession. Probably if he wants to retain some possession which is convenient to him, which is adjacent to his property, you can think of. Oral bidi, ಬೇರೆ ಯಾವ್ದಾದ್ರು ಜಾಗ ಹೇಳಿ ಅಂತ ನಾನು. ಅದಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. What he is saying is, some portion is adjacent to his land. Instead of, now you are seeking possession for 23 guntas alwa. So in that 23 guntas, instead of claiming possession in respect of entire 23 guntas, we can accommodate some 3, 4, 5, 6 guntas which is convenient to him. Probably he may come forward to hand over the possession immediately. So what I'm trying to say is, if you are offering some 3, 4, 5 guntas which is convenient to him, then he may hand over the possession. We can avoid execution and all those things. Monday, no more adjournment. Tuesday. Here, sir. Sir, not that the position of law you know better. Unless the defendant able to establish adverse possession, the suits for possession based on title can't be dismissed. That is the law. And possession is admitted in this case because surrey number 37 is not your property. And you are not saying that it is not the property of the plaintiff's family also. What you are saying is the property of the plaintiff's family. Your only technical contention is rest of the family members are not joined this suit. That can be taken care of. That is understood. See, I have also understood the case that he was only allotted the property up to the road which is there in surrey number 37. Beyond road, he was not allotted in the network. So what is the consequence of that? The property beyond the road belongs to his family, a joint family property, which is not the property of the defendant. See, all right. Sir, one second, sir. The survey report says the property is to the south of road is the survey number 37 to some extent. You show that survey report is incorrect, I will accept your content. Not merely because you yourself say that you have filed form number 7A in respect of survey number 37. You yourself admit that the property belongs to him or his family. So if you say that survey number 37 to the south of road is not yet allotted to him, what is the legal implication? That property remains joined with all the family members. Your technical contention, all the family members are not joined this suit. I will say that he is filing the suit as a representative of the entire family members. When the property goes to the plaintiff, the decree for possession is granted. Since this property is not divided, all the family members can claim sharing the property. That also I can say. This is for them to say whether they want to claim or not. Not a third party. And see your position. You are an encroacher. It's very unfortunate that the encroacher is given such a long hearing. I'm not referring to this case. Encroacher, because of the leniency shown by the courts, people come out with the defense that I'm an encroacher. Encroachment is an offense. No action is taken. See, as a lawyer, I have also appeared on behalf of many encroachers. It's all part of the profession. Alva. But you try to settle the matter if it is possible. No, that's what I suggest. No, that's what I suggested. That's what I suggested. And only for this purpose I'm adjourning. Let there be some settlement. And you can argue. If you want to argue an additional point, you are not prevented. I have made my mind clear. I have not yet taken a conscious decision as to what should I do with this subject, but it appears to be like this. This is tentative opinion formed by the court. This is my way of conducting the case. I want to express my opinion before I start dictating to you. Fine. Right?
And the record had not come up. So that on 1/9 I made a submission and now I got it. Record have come. Not having it. For the alone, my lord, on the earlier occasion, you had been filed in the matter. So it is the change of counsel. Yes, my lord, only to secure certain documents.
Review was allowed?
Review had been.
Not premise, on what ground?
And the RSA has been restored. But to have the rights. In meanwhile, they have attempted to file a memo stating that one of the respondents were being analyzed the LRP respondent. Then he's not to be seen. So I'm filing a memo.
Who is dead?
Yeah, respondent is dead.
Which respondent? Which respondent is dead now?
He is not to be seen, he has left the house. His whereabouts are not known. His respondent,
ಸರ್ವಾಗಿಲ್ವ ಅವನಿಗೆ ಈಗ? Was he served or not? See, on LR application, whether notice has to go now. Forget about that. Whether which LR application is pending.
There is no LR application. I sought for correction of the past record. There was rather record in the review petition. My lord, Ram Krishna was also a party. Now with transfer, this is not available.
He brought a record in the review. But now Ram Krishna is not to be seen in whereabouts not known. So filing that.
Who represented Ramakrishna when RSA was pending? Who represented Ramakrishna when RSA was pending?
No, RSA is pending.
When RSA was pending, who represented Ramakrishna?
The respondent was alive. He died later on. Of the respondent was alive during the RSA. Later on, during pendency of RSA, he died.
During pendency of review petition.
He died. That is he died. His respondent died.
Just a second, sir. During pendency of review petition, respondent died. LR application was filed with the review petition. Notice was issued, and LRs were brought on record, including
The petitioner himself died. And the LRs came on record, my lord.
So respondent is the review petitioner. All right. Review petition was filed by the LRs. Or prosecuted by the LRs. Allah. Review petition prosecuted by LRs. Correct. Now RSA is restored. We appeared for R1E. Review the league. Your wakalat will continue. Wherever he has gone, we are not concerned. If you are saying that he is dead, we are not concerned. But the memo see where he is concerned, where he is staying, where he is whether he is in touch with you or not, it's not the concern. He is alive or not. ಏನಂತೆ memo? What is this memo? Now in RSA, are you going to file wakalat on behalf of the LRs of respondent, original respondent? ಅದನ್ನ ಹಾಕಿ ಅಷ್ಟೇ. Learned advocate. So ತಮ್ಮ ಹೆಸರು? ಯಶವಂತ್. ತೋರಿಸಿದಾರಾ? You have to file wakalat. Learned advocate for respondents number 1A, C to H undertakes to file wakalat. RP Nivedra. But at your risk. ಸುಮ್ಮನೆ ಮೆಮ್ಮ ಬೇಡ ಯಾಕೆ ಸುಮ್ಮನೆ ಕನ್ಫ್ಯೂಷನ್ ಮಾಡಿ reporting that he is elsewhere not know. No, understood. Then file it in the register. Yeah. When do you want? When it comes for the appellant, 6 weeks accommodation to argue the matter. This is not wrong. 15. Appellant. Pass over. Huh? Then appears for the appellant. Then it comes for the respondent. It's a short accommodation. What is on alva? What is? Why? For synopsis, if it is required, I will insist. You can argue the matter. The request of Leonard Counsel for the appellant is this matter on Monday. Then they paid for the appellant is this matter on Monday. Why? The request of Leonard Counsel for the appellant is this matter on Tuesday. Wait a couple of Monday. On 20th of October 2022, the Leonard Counsel for the appellant was permitted to retire the brief, as there was no instruction to the appellant, and notice issued by the Leonard Counsel to the appellant informing his intention to retire from the brief was served on the appellant. Thereafter, the matter was ordered to be listed today. Stop. Name of the appellant is shown in the cause list. Appellant called out. Name of the appellant is called out. Appellant is not present. Appeal is dismissed for non-person. All this matter 2:30 ಮಾಡ್ಕೊಂಡು 2:30 called out ಅಂತ ಮಾಡಿ
two appeals arising out of the same suit. For the first appeal, which is 16th.
You are appearing for one of the appellants?
One of the appellant is connected.
Commence. Yes.
Two titles belongs to Devregowda. 17 scheduled properties.
17 scheduled property.
Some other properties also there. It's subject matter. 17 properties. Devregowda has 3 children. One passed away without issues. Married and passed. Singamma is the second daughter. Third, Manoj Singangowda, son.
So Singamma is the first wife.
She is the daughter of Devregowda. Explain.
You have mentioned as Modalane Indati.
Ullegowda. She has been given ಸ್ವಲ್ಪ ಎರಡು ಮೂರು ರೌಂಡ್ ಅಲ್ಲಲ್ಲೇ Singamma is the daughter of Devregowda. Singannagowda is the son of Devregowda. Singannagowda's daughter is also Singamma. This Singamma, who is the daughter of Devregowda, has been given in marriage to Ullegowda as his first wife. Ullegowda's first wife. Ullegowda has also another wife, that is Varigemma.
Padigeram.
So the plaintiff is.
When Devregowda died?
Plaintiff is.
No, when Devregowda died?
Devregowda died long ago. The issue is the Singamma is the plaintiff. She is the daughter of Singangowda.
See, when you say long ago, there are consequences when I put this question. Whether he died prior to 1956 or after 1956. It is all relevant.
Prior to 1956, because 1946 there was a gifting by Chikkamma with the wife of Singangowda and this Devregowda. Both of them have jointly gifted the property in favor of Pulla. That is the son of Singamma. Little confusing. Singangowda's daughter, Singamma, is the plaintiff. She files a suit for declaration against this Pulla and her mother, Chikkamma. In that suit, this Pulla has taken a defense. Pulla's son, Devregowda has taken a defense. In the year 1946, this mother of plaintiff, that is Chikkamma, and
Pulla is his real name or nickname?
in that gifted itself,
Put as Pulla. ఇక్కడ ఎడతారా అండి ఎడతారా Pulla?
this plaintiff Singamma and her the grandfather.
230. Huh? Which one? 15. ಹಾಕಿದ್ದೀರಾ ಜಗದೀಶ್ HM ಯಾರು ಅವರು ರಿಟೈರ್ ಆಗ್ತಾ ಇದಾರಾ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಾ Learned counsel for the appellant has filed a memo of retirement and the memo is also enclosed by notice issued to the appellant. And the appellant, and also the postal acknowledgement for having one appellant alla many are appellants, also the postal acknowledgement for having delivered the notice. Learned counsel for the appellant is permitted to retire from the case. Registry to show the name of the appellants in the cause list. This matter on 17th November. Permitted. Serial number? The request of learned counsel for the appellant. This matter after 2 weeks.
11. ಇದೆಲ್ಲ ನೋಡ ಒಂದ್ ಯಾವ್ದೋ ಒಂದು ಅಡ್ಜನ್ ಆತ ಎಂತದ್ದು ಗೊತ್ತಾಗಲ್ಲ ನಾನು ಹೋದಾಗ ನಂದೇನು ಹೆಚ್ಚಿಗೆ ಇಲ್ಲೇ ಅದ್ರಾಗೆ ಆದ್ರೆ ಇರಕ್ಕ ಅದೇನು ಕೋಟೆ ಇಲ್ಲ ಅಂತದಪ್ಪ ನಾನು ಲಾಯರಿಗೆ ಫೋನ್ ಮಾಡಿ ಹೋಗ್ತಾ ಇದ್ದೆ ಒಂಚೂರು ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಂಡು ಇದೆಲ್ಲ ತಂದೆ ಮೆಡಿಕಲ್ ಜೊತೆ ಎಷ್ಟು ಕೋರ್ಸ್ ಅಲ್ಲ 29 ಕೋಟಿ ಫೋನ್ ನಂಬರ್ ಯಾವುದು ಸಿದ್ದಮಲ್ಲಪ್ಪ ಯಾರಪ್ಪ ಅವನು ಎಂತ ಟೆಂತ್ ಊಟ ಅಂತ ವೇತನ ಉಕ್ಕಾಜೆ ರಾಮಕೃಷ್ಣ ಭಟ್ಟ ಕೆ.ವಿ. ನರಸಿಂಹನ್ ಶಿವಪ್ರಕಾಶ್ ಪೂಜಾರಿ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ ಅಹ್ಮದ್ ಪಡುಬಿದ್ರಿ ಮೋಹನ ರಾವ್ ಶಶಿ ರಾವ್ ಆಮೇಲೆ ಚಿಂಬುಡ ಅಂತ ಮಾತಾಡೋದು
ಚಿಂಬುಡ ಅಂತ ಮಾತಾಡೋದು ಪ್ರಕಾಶ್ ಚಿಂಬುಡ ಅಂತ ಮಾತಾಡೋದು ಎಲ್ಲ ಎಷ್ಟಾಯ್ತದೆ ಎಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೆಂಟ್ಸ್ 3 ಯಾರ್ಯಾರಪ್ಪ ಎಚ್ ಕೆ ಗೋಪಾಲ್ ಅಷ್ಟೇ ನಾನೇ ನಾನು ಇಲ್ಲೇನಪ್ಪ ಕೋಪ ಚಾಟ್ ಹೋಸ್ಟ್ ಚಾಟ್ in the chat raise hand ಒಂದೊಂದನೇ ತಾರೀಕು ರಜೆ ಇದ್ದು ರೆಸಿಗ್ನೇಷನ್ ಆಫ್ ಸೀನಿಯರ್ ಫೋನ್ ನಂಬರ್ ಎಲ್ಲಿದ್ದೀವಿ ಸೆಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ಮೊಬೈಲ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಬ್ರೋ ಇಲ್ಲ ವಿಡಿಯೋ ಗ್ಯಾಲರಿ ಜುಡಿಷಿಯಲ್ ಪ್ರೋಟೋಕಾಲು ಅದಕ್ಕೆಲ್ಲ ಮೂರು 5 3 6 7
Appeared in the, there was no representation for the appellants in the morning session, no representation in the afternoon session as well. This matter, 17th is the last chance. Speaking?
Responding number 18. Right, my lord, you notice that
You filed application. Who has to pay process? When will you pay? Morning you could have paid. You wanted to save some rupees. Bernard Council for the respondent says that you will pay the necessary process fee by tomorrow. Registry to issue notice. Just a second. You want to impute respond number 8 and 9? You are for whom? No. One and 2. Want some other persons to come on? Oh, no.
Partition, the 23, the early hearing of by the appellate. May be allowed.
Bernard Council for the respondent says that he has no objection to allow application at I number 1 of 2022 filed by the appellant seeking early hearing. Since the appeal is of the year 2007 and since there is no objection by the Bernard Council for the respondent, application is allowed. Early hearing granted. Is this matter for final hearing on 17th November. 16th November. Respond number 2. Notice issued.
Already served, my lord. The respondent number 2A. Alas, 2A is already dead, my lord. And with order dated 22/10/2018. The respondent number 2B already on record in place of respondent number 2A. This application may be allowed. Respondent number 2B already served. Represented.
2B is the LR of R2A.
No, respondent number 2A, my lord. No more. Can you see the
Who is the LR? Who is the LR of 2A?
Yeah, no LR, my lord. And that memo. Memo dated 4/9/2018.
On 4/9/2018, the appellant has filed a memo stating that respondent number 2A is no more. Wow.
That already order was passed, my lord, on 22/10/2018. Not left behind any legal representative.
Order ಆಗಿದೆ ಅದು.
Order ಆಗಿದೆ.
QA ಬಗ್ಗೆ ಆಗಿದೆ. What is pending now?
On 22/10/2018.
Just to come on record now.
Respondent 2B only.
2B na? Yes. Idan togoli madam. IA number 1 of 13 is filed to condone the delay of 208 days in filing the application to bring the legal representative of this is respond number 2. And IA number 2 of 13 is to set aside the abatement. And IA number 3 of 13 is to bring the legal representatives of aforementioned respond number 2. Stop. Notice is served to the proposed respondents. The memo is also filed to the effect that respond number 2A is dead and he has no other heirs. And accordingly, an order is passed on 22/10/2019. Thus, application at I number 1 of 13 is allowed, condoning the delay of 208 days filing the application to bring the LRs and to set aside the abatement. I number 2 of 13 is allowed, abatement is set aside. I number 3 of 13 is allowed, and appellant is permitted to bring respond number 2B as the legal representative of this is respond number 2. Since respond number 2A is dead, application as against respond number 2A doesn't survive. Appellant to carry out amendment and furnish amended cost.
Appellant died on 16/4/2021, filed by 25/8/2021. 100 years delay by some COVID ಇರೋದ್ರಿಂದ ಅದಕ್ಕೋಸ್ಕರ kindly maybe
Notice ಹೋಗ್ಬೇಕಲ್ವಾ?
notice.
She notice I number 1 to 3 of 2021 with the proposed legal representative of deceased respondent. Typed copy of exhibit P5 P7. Appellant to comply the order dated 16/10/2019 within 2 weeks. Survey na? C6.
Subsequently, after appointment of commissioner, before the execution of carrying out of the enclosed upon regarding that extent is not mentioned either in this report or anywhere in the reports are not, but the evidence, the cross examination PW1. Regarding enforcement, defendant admits.
Where do you get it?
Last paragraph of the cross examination. Page 7 of the deposition of PW1.
Page
7.
Page 7 of cross examination of PW1 na? PW. Your for whom? So, your witness says there is encroachment.
My cross examination, they have put a question regarding the encroachment.
Where is that?
Last paragraph.
ಮತ್ತು ಪಾರಿಕತ್ತದ
ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕಿದ ನಂತರ 3 ಗುಂಟೆ ಜಮೀನನ್ನು ಒಪ್ಪಿಕೊಂಡು 7 lines. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕಿದ ನಂತರ 13 ಗುಂಟೆ ಜಮೀನನ್ನು ಒಪ್ಪಿಗೆ ಮಾಡಿಕೊಂಡು ಹೇಳಿಬಿಟ್ಟು ಸುಳ್ಳು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ ಮುಂಚೆಯೇ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಈ ದಾವೆಯಲ್ಲಿ ಈ ಹಿಂದೆ ವಿಚಾರಣೆ ಆದಾಗ ಈಗಲೇ ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ 3 ವರ್ಷದ ಹಿಂದೆಯೇ ದಾವಾ ಆಸ್ತಿಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ನಾನು ಸುಳ್ಳು ಅಂಶಗಳನ್ನು ನೀಡಿ ಪ್ರತಿವಾದಿಗಳ ಆಸ್ತಿಯನ್ನು ಹಿಡಿಯಬೇಕೆಂಬ ಉದ್ದೇಶದಿಂದ ದಾವೆಯನ್ನು ಹಾಕಿದ್ದೇನೆ. ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿರುವ ಜಮೀನಿನಲ್ಲಿ ಮರಗಳು ಇದೆ ಎಂದರೆ ಸರಿ.
Understood. Encroachment understood. But how do you say the extent?
The extent is not forthcoming. But when this cross examination was done.
Understood. There is encroachment. But when you pass a decree for possession, the court must say how much of encroachment is to be removed.
Unfortunately, survey report also is not forthcoming. Based on my pleading and my case.
Who filed application for survey?
Court has.
Who filed application for survey? When the report does not indicate the extent, what you should have done?
I should have examined regarding the extent because it's not forthcoming.
Then
the only recourse is by examining this survey. I should have put a question with it. How many extent of encroachment I should have put a question. Unfortunately, it's not quoted because we have not objected to the report. And simultaneously, I have examined. 6 documents were marked. In the evidence also, it is not.
Where is the counsel for appellant?
That day he had argued. The morning session also he was not. That is the substantial question of law which has been.
Name appears for the appellant. The learned counsel for the heard the learned counsel for the respondent. Further hearing antitala. Heard the learned none appears madam. Heard the learned counsel for the respondent. Since the learned counsel for the appellant is not present, discuss matter to hear the learned counsel for the appellant as a reply to the argument introduced by the learned counsel for the first respondent. Tomorrow, Monday. See, let there be one more survey. Otherwise, how to say that the 13 guntas is enclosed? Password. Good. Sorry. Why do you apologize for that? Who is complaining? He has already commenced his submission. You can sit and listen. He has filed one appeal. He has to commence. He has commenced in the morning. No. What is the hindrance to hear his submission? You don't like his submission? Huh? Sit down and make notes. When you are enrolled, then you should be able to argue this matter. Senior is engaged in another court, there is an opportunity for you. Make use of it. Yes, commence his submission. It requires a lot of time to understand the genealogy. That money.
First of all, by saying that the original duty has not been produced by the defendant, that defendant number 1. Therefore, this will be decreed for partition without being for further has been decreed for partition.
What opportunity you wanted the court to give?
There are several persons. I mean, initially they will find for declaration.
So what you are saying is other members are not made parties.
There is no opportunity and other properties are there. This two properties only the gifted property.
So you are for dependent?
I am for dependent. Dependent number 1. I will explain the genealogy. The Purusha Javregowda had a daughter.
You said there is one difficulty. What is the difficulty?
The original gift deed. Now, my lord, I inquired. The original gift deed is there. The dependent number 1. I will collect and verify that there is a original or not. It shows in the photo. That is the original gift deed.
You want to produce it?
If that is the original, I wanted to produce it. It has the bearing on the case.
They denied the execution of gift deed?
Yes.
They denied.
They denied. And I produced the certified copy. That is disbelieved by the first appellate court, saying that section 90
presumption is not available since it was obtained only prior to the suit. Therefore, if original is there, the entire list will be.
Who executed gift deed?
Yoregoda and Chikama, second defendant and father-in-law.
In favor of whom?
In favor of the father of the defendant and mother. So plaintiff is the daughter of that Chikama, second defendant daughter.
You have made his job easy. He's seeking adjournment and you also want an adjournment.
Not like that. My lord, ultimately.
The request of learned counsel for the appellant as well as the respondent. Is this matter on Tuesday? Happy? Yes.
Sorry.
Huh? 2006 matter. But 2006 matter don't seek adjournment. No passport at 340. You start. Who filed this appeal? For defendant. What happened to the suit? Why? Why are not at the file? This matter is listed. This matter is being listed since last 10 days. Why are not at the file? What was the nature of the suit? So you were aware that this case was called in the morning. Then why you are not at the brief? You need not seek apology. Probably the apology is due to the client whom you represent. On what basis plaintiff is seeking injunction? You have to read the file, basic facts. So unless you read the file, will you know the facts? So you should read the file, should make small synopsis. Then you should instruct your senior. You should cite the relevant judgments to your senior. Then your senior will gain confidence in you. Senior will realize that he has read the brief, he has understood the fact, he has understood the law, and senior will allow you to argue the matter. You have to do something to earn the confidence of your senior. So otherwise, what happens is, client has entrusted the matter to the senior. How the senior will entrust the matter to the junior? Because the client says, senior should argue the matter. But if the senior understands that the junior has read the brief, understood the case, senior will automatically entrust the matter to the junior. See, unless you read the brief, unless you apply the mind, there won't be any progression. You could have used this opportunity. When did you enroll? Huh? 24, 22, 2.5 months, sir. The request of current counsel for the appellant. Is this matter on Monday? You made argument Monday. You do one thing, you prepare the synopsis. Synopsis is not relating to the date of filing of return statement, date of filing of suit, date of framing of issues, Allah. You must prepare the gist of the case. What happened when in one page. It should be in bullet point. Specific performance refused or granted? Refused. You are for plaintiff?
I'm for the plaintiff.
Concurrent finding.
Concurrent finding. Both the courts hold. That the execution of agreement of sale, though dispute, court has held.
Let us let me understand some basic facts. Date of agreement?
Agreement of sale is between 10/9/1986.
1986. Consideration amount agreed?
Sale consideration is ₹20,000.
How much paid?
Earnest money paid is 16,500 under the agreement of sale.
Last date for payment of balance amount?
2 months was the period.
2 months. When the suit was filed?
The suit is filed on 7/11/1986.
Property extent?
It's a title property.
Site?
It was adjoining to the plaintiff's property. That's why, my lord, as a matter of convenience, this was sought to be acquired. Then what happens is, my lord, during the subsistence of agreement of sale, property is sold in favor of defendant's tool.
The subsequent purchaser. Your agreement is unregistered.
Agreement is unregistered.
How do you say that defendant number 2 and 3 were aware of the transaction?
In fact, defendants 2 and 3 caused me a notice stating that they hold an agreement of sale. Therefore, my lord, sale deed will have to be executed. A copy was forwarded. That's how, my lord, trial court.
How they issued notice to you? 2 and 3?
It was a copy marked to, my lord, the plaintiff, where, my lord, a caveat was also submitted. The trial court on appreciation finds that each notice being issued, they were aware of the agreement of sale in my opinion. They are held to be not bona fide purchases. Readiness and willingness, my lord, is also held in my opinion. Still, my lord, in view of, my lord, the property, my lord, first defendant and brothers also own the property. The trial court refuses, my lord, grant.
So the property was jointly owned?
Jointly owned, my lord, which was not, of course, known to us. Govindappa was the father of.
Just a second. Owned by D1 and his brother.
D1, the father of D1 was the owner of the property.
Father of D1. How many issues he has?
He had 2 other brothers. One Timmappa and the other 2 brothers were there.
The father of D1 was holding the property.
He was owning the property. D1 alone executed the agreement.
I'm not worried about the brothers of the father of D1. How many children D1 had? This father had?
Two other.
Other 2? No. They were not parties.
They did not execute.
So vendor had only 1/3 share.
1/3 share.
1/3. So what is the extent of property?
Yes. Abutting to my property, my lord, it is east to west, 434 feet. 434 feet. And 1034 feet and north to
4 feet?
4 feet and 3/4 inches.
4 feet?
ಪೂರ್ವ ಪಶ್ಚಿಮ 4.75 ಅಡಿಗಳು. ದಕ್ಷಿಣ ಭಾಗದಲ್ಲಿ ಅಂದರೆ ಮಠದ ಹಿಂಭಾಗದಲ್ಲಿ ಕ್ರಾಸ್ ಜಾಗ ಸೇರಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 10.75 ಅಡಿಗಳು, ಉತ್ತರ ದಕ್ಷಿಣ 35 ಅಡಿಗಳು. Irregular site.
Both of them, so nearly 350 square feet.
Yes. A little more maybe.
Nearly one third of a gunta. Ashtu 350 square feet to one third gunta, correct. Otherly now we are having one. Very small extent. Doesn't serve the purpose.
Courts have not dealt in that way.
That's how I understand.
I am concur. But having read the agreement of sale as proved.
Understood. Now, assuming that I'm going to accept your contention, but having held that agreement is true.
I am entitled for one third.
And having held that remaining purchasers are not bona fide purchasers. The court can could have passed a decree for one third share of your vendor. But that one third share is too small. It cannot serve any purpose.
Courts have not dealt in that way, my lord.
Now, if I am to allow your appeal, what follows from the decree? Will you be able to enjoy the decree?
Because my lord,
other than causing some sort of inconvenience to defend number 2 and 3, who may not be bona fide.
Because my lord, I own a property, my lord, adjoining to that.
I'm trying to understand. This one third is decree is granted in respect of a small portion of land, which is less than or maybe around 350 square feet. Then if one third, to the extent of one third share, this decree for specific performance is granted. Will it serve any purpose for you?
Yes, my lord, because I own my lord adjoining. It was sought to be acquired as an opportunity because it was adjoining. So that's all.
Now, anyhow, depend number 2 and 3 have purchased the property, right? If that portion is removed, one third portion is removed from their possession, and what will the consequence for the remaining 2/3?
They continue to possess.
They continue to possess. Will they be able to use it?
The approach of Milord as observed by your lordships. It's not being had by the trial. Trial court did not went on a tangent and say that Milord the property because he had only the other co-owners were there.
That is understood. That is understood. So when your intention was to purchase entire 350 square feet. Now no court is in a position to grant a decree for entire 350 square feet. Alva. So probably the trial court, appellate court are right in dismissing this suit.
Appellate court, Milord, that there's another lacuna that does not refer to Milord the evidence of record. And all of us.
No, understood. No, let us say no. I am on this next level. Agreement proved, fine. Defendants are not bona fide purchasers. Understood. What is the consequence of that? You are having only one third share. Your vendor had only one third share. Now, if a decree is granted for one third share, and if there is a decree for partition and separate possession of one third share, will it be of some consequence for you, which you conceived when you entered into an agreement to purchase entire 350 square feet? One aspect. Second thing, will it not create more problem for the remaining 2/3 shareholders? At least as far as remaining 2/3 share is concerned, technically they are bona fide purchasers. Technically, the reason is there was no agreement by the remaining 2 sharers.
But the question of hardship that once they are held to be not bona fide purchasers. The question of hardship need not be gone into.
For 2/3 share, they are bona fide.
No, that's not the that's not the court's how it is
no, that cannot be discussed by the trial court and the first court. Now, before this court, this matter also comes up for consideration. Now, what will be the consequence? The law is well settled. Provision of law is also very clear. Merely because an agreement is said to be lawful and proved. It again is the discretion of the court whether to grant a decree for specific performance or not. So the court has to see. There may not be strict evidence or evidence to the liking to say that there is hardship. It is not a case where the specific performance is to be granted or something like that. But still the court can take into cognizance the fact that the remaining 2/3 share belongs to defendant number 2 and 3.
The question I pose myself is to my lord. Courts having held that my lord, they are not bona fide purchasers.
my lord, it could be, their hardship could be a consideration, my lord.
See, if entire property belong to the vendor, then that question cannot be looked into once it is held that they are not bona fide. As far as 2/3 share is concerned, still the court can say that they are bona fide. See, it is possible for them to say, we were aware of this agreement. Agreement was defective in the sense it was by only one of the persons. We purchased the property from remaining 2 sharers. So as far as 2/3 share is concerned, there was no agreement. So we proceeded. This contention is permissible under law.
However, was not put forward. That was not.
Now decree for 1/3 share may not serve the purpose. Now what is the position in the actual spot now?
So now, my lord, I'm not aware. In fact, I had communicated to my counsel, counterpart, child court. They had to get back to me, my lord, but told there is some widening of roads and properties. And so much of suit property, I'm told, my lord, that so far as property that belong to my clients, my lord, there is some, my lord, acquisition and things like that. There is some shrinkage in the property. These persons have virtually lost some property.
Appellant. Now, what has happened to the defendants have put up any structure there now?
Sorry, my lord, I am not able to.
If any structure has come up, probably it is not a case where the court could say that 1/3 share is to be demarcated.
As I found from the evidence, that was not there as of then. Present situation, my lord, I am.
2007. See, what happens is 350 square feet, 1/3 of a gunta. If I again divide this property into 3 shares, 3 parts, this 1/3, just a second, this 1/3 probably will be of some consequence for you because you are having the remaining portion, but remaining 2/3 likely to go waste. Considering the extent, we don't know. It is not even half a gunta, 1/3 gunta. If I presume that your extent is correct, that 10 into 35, 350 square feet. Wow. $1,089 divided by 3, 363 square feet. 1,089 is 1 gunta. Divided by 3, 363 square feet. So 1/3 of a gunta.
110 square feet. Maybe 10 by 10 or something like that.
So probably that will be of some consequence for you, some utility for you. But what about remaining 2?
To suffer, my lord, having purchased a property which is, my lord, knowingly, my lord, there exists an agreement. That's the price they pay for it.
In that event, what will happen is, assuming that appeal is allowed, the suit is decreed, and division is ordered, and the court further says that 1/3 share belonging to your vendor should be allotted to you, adjoining to your own property now. What will happen to remaining 2/3? It becomes waste.
Then, my lord, they might utilize for whatever the purpose they have been now.
Is it possible for them to utilize? If they already put up some structure, who appears for the respondent?
Earlier, Rajendra Prasad Associates were on the call.
Sunil Varu. Heard the learned advocate appearing for the appellant. This matter. You want to submit anything else? I'll post this matter for hearing the submission of respondent. After hearing him, you can give reply. If I say it as partner, probably may appear. Or the learned advocate appearing for the appellant.
Any further submission with permission, I'll know next day.
You have got right to hear the learned counsel for the respondent. Is this matter on Tuesday?
ought to have, my lord, the thought of compensating either party that would have been, my lord. What stuck to my lord, after hearing my lord, compensation should have been, my lord, either me or my lord the others. Now that my lord first amendment is out. We are the sufferers.
Decree for refund is not ordered.
Refund was ordered. Refund with the minimal interest of 2% was ordered. And we were in appeal on all these scores.
So what you can say is this, your vendor has misled you in the sense he has not disclosed the fact that there are two other owners to this property. But at the same time, you have not carried out due diligence. The property once belonged to his father. Could have easily said that there are two other sharers.
Now comes to my rescue, assuming that there is an agreement that decree in so far as that person's share is concerned, my lord, is permissible under the act.
It is permissible. If it is larger extent, say 1 acre of land, I would have allowed the appeal.
Great respect, my lord, irrespective of the extent.
No, I would have allowed the appeal. The reason is because it doesn't cause any hardship to anyone. 1 acre you can utilize. 1 acre, just give an example. If it is 4 guntas of vacant site, I could have said 1 gunta you can make use of. Too small. The decree.
Property.
In the sense, when he has purchased remaining 2 shares, he should be in a position to make use of it. Just find out what is the situation there, what they are doing now in respect of that property. Tuesday for further hearing.
Matter has been dismissed for non-prosecution, that is for specific performance, this is for declaration filed by defendants. That is allowed in appellate court. Now my suit is used in this appeal, but I have to file an application for recalling.
I didn't follow what you said. Repeat again.
171 appeal. Is my appeal, plaintiff appeal. That is for suit for specific performance. The another suit is filed.
What happened to suit for specific performance?
Dismissed. Trial court, both the suits were dismissed.
All right. Then what happened?
Defendant filed an appeal for declaration. That is allowed.
Defendant also filed a suit. Suit for?
Declaration.
Of what?
Amendment is for that agreement.
Agreement is?
Void.
All right. Then what happened?
They also filed an appeal.
What happened to that suit? What happened to the suit filed by the dismissed? Then what happened? Which appeal?
RSA 170. 171 our specific performance we are dismissing.
When it was dismissed? When?
After that we have filed an application. That is also recalling application also dismissed.
2000? No. Once the application for recalling is rejected, where is the scope?
Was also in the
That can't be the ground to adjourn the matter. Your appeal is dismissed. Then you file an application for recalling the order. Application contains several objections. You don't remove the office objections. That application is dismissed. So there is a default on your part on 2 counts. One is dismissal of regular or second appeal, and second one is dismissal of application to recall the order. Under your own mistake, relying on your own mistake, taking shelter under your own mistake, you want one more adjournment in the pending case. And it's 2 years now. 1 year. Then you commit a mistake and taking shelter under the same mistake, you want one more adjournment. So that's what it actually means. Why this matter is to be adjourned? Because you made a mistake in another appeal. You did not comply office objection. No, I'm not asking you to file an application. Which court will file and ask the party to file an application to recall the order? Nobody will. So when this matter was notified yesterday, why did not you move an application today to recall that order? Party is not interested. You are informed them, they are not interested. Apologies, apologies. I would only dismiss this appeal on the ground that in the earlier suit, the very same agreement is declared to be null and void. So, source for passive performance based on the same agreement is not maintainable. Why? Why the court should show indulgence in a 2007 matter? And that too because of the mistake of the appellant. You have informed the appellant. Appellant has not turned up. You have done your job. Your responsibility is over. Tell me one valid reason as to why this case has to be adjourned when the appellant himself has committed a mistake. See, if it is 2010, 11, 12 matter, would have adjourned. 2007 matter. Appellant is really interested in specific performance. Huh? What is the requirement of specific performance? Under section 16C. The specific relief act. What is the requirement under section 16C? ಯಾವಾಗ enrollment? Vintina. See, this is easy disposal for any judge. Agreement is held to be void in another case. That judgment has attained finality. So the suit for specific performance is not maintainable. No substantial question of law would arise in RSA 170 of 2007. Is dismissed. 4 sentence comprehensive order. Easy disposal sigala nam RSA final hearing. Easiest disposal, not dismissal for prosecution, on prosecution, dismissal on merit. Senior ಬಂದ್ರು ಅಷ್ಟೇ same law. ನಿಮ್ಮ ಹೆಸರು? Narendra. The request of learned counsel for the appellant.
Respondent kindly mark the presence of respondent number 1A to F.
The request of learned counsel for the appellant. This matter. On 16th November. Learned counsel for respond number
1A to F and H.
F and H appears to video conference.
Yes, Lord. Much obliged.
ಬೆಳಿಗ್ಗೆ ಬಂದಿದೆ ಕೊಡಿಲ್ಲ ಹಿಂದಿದೆಯಾ?
last time I
The council was there.
Not able to present, my lord, I was held up in portal number 1.
Small point.
Yes, sir.
I posed a question.
Yes, sir.
Now there is a report which says that there is encroachment, but extent of land is not mentioned.
Extent of land is the original land belong to the respondent, my lord. Respondent to defendants, my lord, is about 3 acres or 12 guntas. Now, in the handwritten RTC, throughout 30 years, if it is going to be increased, the extent is going to be increased in respect of the said survey number. Either there must be purchase of the property, or there must be grant of the property by the government, or something must be there. Here, there is no document to show that how the property from 3 acres 12 guntas to 3 acres 21 guntas was increased. Yes, that is how we filed the because towards the eastern side of the property.
Why you didn't urge this point other day?
Afterwards, my lord granted the time. My lord, I gone through that. That is the point, my lord. That is the point which we have canvassed.
It appears to be the best point.
That is the point, my lord.
You could miss the best point.
That, my lord, afterwards I noticed your lordship.
If I had passed the order dismissing your appeal.
No, my lord,
You can't miss the best point.
yes, I sorry. I noticed, my lord, after going through the entire paper.
What is the finding of the trial court and the first appellate court on this point?
There is no finding to that effect, my lord. How the extent of land has been increased compared to the handwritten RTC and the.
That was your stand in the written statement.
My lord.
Was it your stand in the written?
That is our stand in this written statement clearly. And in their pleading, that's why, my lord, I wanted to take your lordship's attention to the entire pleading. There is no pleading at all by them. But on the other hand, we have stated that how the property more accurate.
Is the ground urging the appeal memo now?
Yes, your lordship. There is no finding recorded how this property was extended. ಅಲ್ಲಿರುವುದು 3 ಎಕರೆ 12 ಕುಂಟೆ ಪ್ಲಸ್ 3 ಕುಂಟಾಸ್ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿದ್ರೆ 3 ಅವ್ರ ಫೋನ್ ಅಲ್ಲಿ ಐದು 711 it appears it is posted. It appears it is posted to 711, my lord. Morning I was held up in portal number 1, your lordship. That's why I could not be present, my lord. Otherwise, I wanted to go on with the matter, my lord, in all this.
Not you, some of your colleagues.
Yes, my lord. I will make it sure, my lord, that my colleagues.
Where the handwritten RTC is produced?
Handwritten RTC.
ಬರ್ದಾಯ್ತಲ್ಲ ಆಯ್ತಾ ಮಂಡೇ ಒಂದು ಬೇರೆ ಮ್ಯಾಟ್ರ್ ಯಾವುದಿಲ್ಲ ಯಾರಿಗೆ ಬಂದಿರ್ಲಿ ಮಂಡೇನೆ ತಗೋತೀನಿ ಬಟ್ ಕೇಳಿದ್ರೆ ಕೇಳ್ಬಿಡ್ತೀನಿ ಮಂಡೇ ಟೈಮ್ ಸೇವ್ ಆಗುತ್ತೆ. Where is the handwritten RTC?
Paper book to lordship will get it on exhibit B1, 1/3. Totally measured, my lord, 3 acres 12 guntas, my lord. Kharab land is there 4 guntas. 3 acres 21 guntas they claim under by bifurcating the property. There, my lord, may be permitted to read, my lord, their plaint, your lordship. Whether there is any substance in the plaint, my lord, how they got the property. That's what in the beginning I wanted to draw your lordship's attention to their pleading. There is no pleading, my lord, how this property.
You wanted, but you prevented.
No, your lordship did not prevent your lordship. Your lordship asked some other questions, your lordship. That's why I took your lordship's attention to that only, my lord.
So I derailed your argument.
No, it is in this court, my lord, I don't find, my lord,
maximum accommodation will be made, my lord, to the make a submission. Paper book, my lord, page number 1. Simply they say in para 2 and 3. Plaintiffs are the absolute owners in physical possession and enjoyment of my lord, got it, my lord, in my paper book.
Yes.
Plaintiffs are the absolute owners in.
Understood. I understood your point. Now show the difference in this regarding your statement.
Yes, written statement, my lord, the next page itself is my written statement. Kindly come to para 2, the last para 2. It is false to say that the plaintiffs are the owners of survey number extent of 1 acre 21 guntas of land. In the suit survey number, it is false to say it is in possession of the suit property. It is also false to say that there are 2 jackfruit trees, 1 tamarind tree and 1 mungai tree and 7 jali trees. It is false to say so and so that they are owners.
You never said, in specific terms, you never said he only owned 3 acre 12 guntas.
3 acre 20. Their case is that 3 acre 12 guntas is they are the owners of the property, which was to be divided. That's what they say.
You never said
Yes.
that undivided survey number 1/3.
Yes, it is an undivided survey number.
You never said undivided survey number 1/3 measured only 3 acre 12 guntas. It's not your style.
Assuming that it is not stated, your lordship. But how do they get the extent extra land, my lord, other than the land which is owned by them ancestrally? Is responsible.
In your evidence,
Yes.
is there any cross examination on this point?
Examination, your lordship, for 23, my lord. Yeah.
You come to page number 009. Page number 9.
0019.
009.
009.
Cross examination dated 27/7/2000. Alva.
009. Yes, sir.
Yes, this is plaintiff alva. Plaintiff cross examination.
Plaintiff's class examination.
Just a second. MM ಅವರಿಂದ ಮುಖ್ಯ ವಿಚಾರಣೆ. That is plaintiff alva.
Yes, plaintiff. ಇದೆಲ್ಲ plaintiff ದೇನೆ ಇದೆಲ್ಲ.
Party ಸವಾಲು 001. 011.
011.
ಓದಿದನ ನಮ್ಮ ತಂದೆ.
ನನ್ನ ತಂದೆ ಮುದ್ದವನ್ನಪ್ಪ ಮತ್ತು ನನ್ನ ದೊಡ್ಡಪ್ಪ ಹೊನ್ನೇಗೌಡ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ತಂದೆಯವರ ಪಾಲಿಗೆ 3 ಎಕರೆ 12 ಗುಂಟೆ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 1B ನಲ್ಲಿ ಬಂದಿತ್ತು. ದಟ್ ಇಸ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್. ನಮ್ಮ ತಂದೆ ಮತ್ತು ನನ್ನ ದೊಡ್ಡಪ್ಪ ಮಾಡಿಕೊಂಡಿರುವ ವಿಭಾಗದಂತೆ ಜಮೀನುಗಳು ಖಾತೆ ಬದಲಾವಣೆ ಮತ್ತು ಕೋಡುಗಳಿಲ್ಲದ ಕಾರಣ ನಾವು ಪುನಃ ಅಣ್ಣ ತಮ್ಮಂದಿರು ಸೇರಿ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. ಎರಡನೇ ಪಾಲುಪಟ್ಟಿ ಎಂದರೆ ನನ್ನ ದೊಡ್ಡಪ್ಪ ಮಕ್ಕಳು ಮತ್ತು ನಾವು ಸೇರಿ 1967ರಲ್ಲಿ ಮಾಡಿಕೊಂಡಿರುತ್ತೇವೆ. ಈ ದಾವಾ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿ ಸದರಿ ವಿಭಾಗದಲ್ಲಿ ನನ್ನ ಮತ್ತು ನನ್ನ ತಮ್ಮ ನಾಗೇಶನ ಭಾಗಕ್ಕೆ 1 ಎಕರೆ 21 ಗುಂಟೆ ಭಾಗ ಬಂದಿರುತ್ತದೆ. ನಾನು ಈ ಕೇಸಿಗೋಸ್ಕರ ಪಾಣಿ ಮತ್ತು ಕೋಡ್ಗಳನ್ನು ಬದಲಾವಣೆ ಮಾಡಿಕೊಂಡಿದ್ದೇನೆಂದರೆ ಸರಿ. ಈ ಅಡ್ಮಿಟ್ಸ್ ಮೈ ಲಾರ್ಡ್, ಫಾರ್ ದಿ ಪರ್ಪಸ್ ಆಫ್ ದಿಸ್ ಕೇಸ್ ದೇ ಗಾಟ್ ಕೋಡಿ ವರ್ಕ್ ಡನ್. ನಿಶಾನೆ P1 ಅರಿದಿರುವ ಭಾಗವನ್ನು ಇಲ್ಲಿ ಇದ್ದಿರುತ್ತದೆ.
ಆಗಲ್ಲ. Total extent is 3 acres 16 guntas. There are 4 guntas.
Yes.
Is 3 acres 12 guntas. That is in 1/3.
Yes.
Subsequently 1/3 is subdivided into 3A and 3B.
Yes, 3 and 3B.
Wow.
So it must be one.
Just a second. 3B dalli.
Yes.
3B dalli 1 acre 21 guntas. 3A dalli ಎಷ್ಟು?
3A ನಲ್ಲಿ ಇಲ್ಲಿ ಅದನ್ನ 3A ನಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ 1 acre. Next I will read it to you last. 3A ನಲ್ಲಿ.
Where is the RTC for 3A?
3A RTC, my lord, it is not forthcoming in the record, your lordship. 3A.
All right. Without producing RTC of 3A.
Yes.
How do you say that there is extension of extent of land?
But if the property 1 acre 3 acres 12 guntas, my lord, according to the handwritten RTC, it is divided among the brothers. That must be either equally divided or.
It is up to them.
That's correct, your lordship. That's correct. I am not saying so.
How many brothers?
There are 3 brothers. There are 3 brothers. That's what, my lord. Now,
one brother is allotted 1 acre 21 guntas.
1 acre 21 guntas.
What about other 2 brothers?
ಬೇರೆ ಅವರು 4 ಜನ ಇಷ್ಟು ಮಾಡ್ಕೊಂಡಿದ್ವಿ ಅಂತ ಅವರೇ ಹೇಳ್ತಾರೆ. 4 ಜನ, my lord, there are 4 people who have divided the property. That's what they say, my lord.
Equally ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Equally ಅಂತ ಹೇಳದೇ ಇರಬಹುದು. Equally ಅಂತ ಹೇಳದೇ ಇರುವೆ 4 ಜನರಲ್ಲಿ ಇಬ್ಬರೇ ಮಾಡ್ಕೊಳ್ಳಿ, 3 ಜನನೇ ಮಾಡ್ಕೊಂಡ್ರು ಸಹ the extent cannot be extended is by responsibility.
Unless you are in a position to say
yes,
that 1 acre 21 guntas is allotted to X.
Yes.
And again 1 acre 21 guntas is allotted to Y.
Yes.
And remaining 1 acre 21 guntas allotted to Z.
Yes.
And if you compute all these three things, you will exceed 3 acre 12 guntas.
That is, my lord, they have,
You cannot presume equal division.
it is in their statement, it is available, my lord.
Like,
How much they have, this one, my lord, is stated.
why,
Now divide market
why do you want to speculate? Why don't you produce survey number? Why didn't you produce survey number 13B?
ಮಾಡಬೇಕು ಅಲ್ಲಿ ಅದನ್ನು ಮಾಡಿ ಮಾರ್ಕ್ ಮಾಡಿಸಿ ಮಾಡಬೇಕಾಗಿತ್ತು. What is available, my lord, I can say before this court. What is not there, I cannot improve, my lord. But the fact remains, my lord, if an extent of land is 3 acres 12 guntas plus 4 guntas kharab land, how can 321 guntas to be 3 acres 21 guntas has to be?
How do you establish 3 acre 21 guntas? Food property is only 1 acre 21.
That's what their case. 3 acres 21 guntas, we are the owners of the property. ಅಲ್ಲ ಅವರು ಅದನ್ನೇ ಹೇಳಿದವರು ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ
1 acre 21 guntas sir.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ 1 acre 21 guntas ಓಡಿ ಆದ್ಮೇಲೆ, ಬಟ್ ಒರಿಜಿನಲ್ ಸರ್ವೆ ನಂಬರ್ 3 acres 12 guntas.
ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
ಅವ್ರು ಹೇಳಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ರಿಸೈಸ್ ಆಗಿ.
Sir, it is not like that.
So what they should have done is, my lord, they should have explained original survey number. Thereafterwards, a survey number, a part of that survey number has come to my share to the extent of this much and helbeko. That is no, there is no feeding.
What they say is 1 acre 21 guntas is allotted to their share.
ಪೋಡಿ ಆಗಿದೆ ಅಂತ ಹೇಳಿದವರು ಪೋಡಿ ಮಾಡಿಸ್ಕೊಂಡ್ವಿ ನಾವು ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
1 acre 21 guntas is allotted to their share. That is their case.
Yeah, that is their case, my lord. 1 acre 21 guntas allotted out of which property is the question?
Out of 3 acres.
Out of 3 acres 12 guntas. Out of 3 acres 12 guntas is a one survey number. One survey number was coded.
Yes.
After the division, they got it coded to each of the persons.
How much?
Out of 4 persons, my lord. Adu obbobbarige ististu.
How much? Adun torsani.
ಹೇಳ್ತೀನಿ.
Unless you are in a position to say.
Yes.
Would.
Yes. My lord, may kindly see 007, my lord. 007. Before that, I will take your lordship's attention from 006, my lord.
Just to pinpoint the
PW
division.
ಸರ್ವೆ ನಂಬರ್ 1/B ಯಲ್ಲಿ ಇದು 9091ರಲ್ಲಿ 1 ಎಕರೆ 21 ಗುಂಟೆಗೆ ಪೋಡ್ ಆಗಿದೆ ಎಂಬುದು ಸರಿ. ಮೈಲಾಡ್ ಕಾಟಿಲ್ಲ, ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ. ಅಲ್ಲಿಗೆ ಫುಲ್ ಟೆಕ್ಸ್ಟ್ ಓದಿದ್ರೆ
4 ಪೋಡುಗಳಾಗಿವೆ,
4 ಪೋಡುಗಳಾಗಿದೆ ಎಂಬುದು ಸರಿ. ಈ ಪ್ರಕಾರವಾಗಿ ವಿಭಾಗ ಮಾಡಿಕೊಂಡಾಗ ಸಹ ದಾಖಲೆ ಇತ್ತು. ಆ ದಾಖಲೆ ಬಾಲುಪಟ್ಟಿಯಾಗಿರುತ್ತದೆ, ಆದರೆ ನೋಂದಣಿ ಆಗಿರುವುದಿಲ್ಲ. ಈ 4 ಭಾಗಗಳಲ್ಲಿ ಉತ್ತರ ದಕ್ಷಿಣವಾಗಿ ಬದುಗಳನ್ನು ಹಾಕಿಕೊಂಡ ಮೇಲೆ ಹೇಳಿದ 4 ಜನರು ಅವರವರ ಸ್ವಾಧೀನದಲ್ಲಿ ಅವರವರು ಇದ್ದಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿ. ನಮ್ಮ ತಂದೆಯವರಿಗೆ ಮಧ್ಯಭಾಗದ ಒಂದು ಸೀಳು ಸ್ಟ್ರಿಪ್ ಆಫ್ ಲ್ಯಾಂಡ್.
Cross examination.
Yes. Cross examination. 4 ಭಾಗ ಆಗಿದೆ ಅನ್ನೋದು they have to it. If it is so, ಒಬ್ಬರಿಗೆ 10 ಗುಂಟೆ ಬಂದಿರಬಹುದು, ಒಬ್ಬರಿಗೆ 20 ಗುಂಟೆ ಬಂದಿರಬಹುದು, ಒಬ್ರು 1 ಎಕರೆ 12 ಗುಂಟೆ ಬಂದಿರಬಹುದು. ಅಲ್ಟಿಮೇಟ್ಲಿ ಮುಂದಕ್ಕೆ ಹೋಗ್ತೇವೆ. ನಮ್ಮ ತಂದೆಯವರಿಗೆ ಮಧ್ಯಭಾಗದ ಒಂದು ಸೀಳು ಸ್ಟ್ರಿಪ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಬಂದಿದೆ ಎಂಬುದು ಸರಿ. ಈ ಸೀಳಿನ ಪೂರ್ವ ಭಾಗಕ್ಕೆ ರಾಜಣ್ಣನ ಜಮೀನು, ದಟ್ ಇಸ್ ದಿ ಅಪ್ಲೈನ್, ಇದೆ ಎಂಬುದು ಸರಿ. ನಮ್ಮ ಜಮೀನಿನ ಪಶ್ಚಿಮ ಭಾಗಕ್ಕೆ 2 ಸೀಳುಗಳು ಇವೆ ಎಂಬುದು ಸರಿ. ನಮ್ಮ ಅನುಭವದಲ್ಲಿ ಇರುವ ಸೀಳಿನಂತೆ ಸೀಳಿಗಿಂತ ರಾಜಣ್ಣನ ಅನುಭವದಲ್ಲಿರುವ ಸೀಳು ಭಾಗವು ತಗ್ಗಿನಲ್ಲಿರುತ್ತದೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ಕಮಿಷನರ್ ಅವರು ಬಂದಾಗ ನಮ್ಮ ಜಮೀನಿಗೂ ಮತ್ತು ರಾಜಣ್ಣನ ಜಮೀನಿಗೂ ಮಧ್ಯೆ ಇರುವ ಬದುಗಳನ್ನು ತೋರಿಸಿದ್ದಾರೆ ಎನ್ನುವುದು ಸರಿ. ಈ ಬದುವಿನಿಂದ ಪಶ್ಚಿಮ ಭಾಗಕ್ಕೆ ನಮ್ಮ ಅನುಭವದ ಜಮೀನು ಇದೆ ಎಂಬುದು ಸರಿ. ಆ ಬದುವಿನಿಂದ ಪೂರ್ವ ಭಾಗಕ್ಕೆ ರಾಜಣ್ಣನ ಜಮೀನು ಇದೆ ಎಂಬುದು ಸರಿಯಲ್ಲ. ನಮಗೆ ಬಂದಿರುವ ಜಮೀನಿನಲ್ಲಿ 4 ಪೋಡುಗಳಾಗಿವೆ ಎಂಬುದು ಸರಿ. ಸರ್ವೆ ನಂಬರ್ 1/3A ಈ ಭಾಗವು ಪುಟ್ಟಯ್ಯಗೆ ಸೇರಿದೆ. ದಾವಾ ಸೊತ್ತು ನನಗೆ ಸೇರಿದೆ. ಸರ್ವೆ ನಂಬರ್ 1/3C ಯಲ್ಲಿ ಸೋಮಶೇಖರನಿಗೆ ಸೇರಿದೆ. 1/3D ಮುತ್ತುಂಜಯ ಅವರಿಗೆ ಸೇರಿದೆ. ಸರ್ವೆ ನಂಬರ್ 1/3 ಯಲ್ಲಿ ಯಾವ ಭಾಗದಲ್ಲಿಯೂ ಹೊನ್ನೇಗೌಡರ ಮಗ ಪುಟ್ಟಯ್ಯ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲ ಎಂದು ಹೇಳುವುದು ಸುಳ್ಳು. They won't say extent of land owned by them. That's correct, my lord. That's correct. But as a reasonable man, my lord, he should have said what is the total extent of land owned by them after the partition, my lord.
1 acre 21 guntas.
1 acre 21 guntas apart from that, my lord. So 4 share ಆಯ್ತಲ್ಲ, 3 ಎಕರೆ 12 ಗುಂಟೆ.
If it is your case.
That's correct, my lord.
Just a second. If it is your case.
Yes.
That they have apportioned more property than what is available to the family.
Yes. That's what
you should be more.
That's absolutely right, your lord. Absolutely right.
3 acre 12 guntas belong to them, not this.
Yes.
Wow, that is not in this. They divided the property, that is also not in this.
Yes.
Now he says 1 acre 21 guntas is allotted to his share.
Yes.
That is less than what was available to the joint family.
Joint family.
120 is less.
Yes.
If you are saying that, while effected 4 division, the property.
Yes.
They also included the property which was not there in the family.
Yes.
Then it is for you to say so.
That's correct.
And establish this for them. That is not established. Sir, in your absence, what I have said is.
May I request, my lord, kindly come to the reasonings of the 041, my lord.
Oh.
That is extent is also shown, my lord.
Really?
041, my lord, 041. Reasons, my lord. 041, 40, it starts from 40.
Oh.
My lord will get it, my lord, actual figure, my lord.
Yes.
In para, in the second 7, para 7, my lord. PW1, in his further, my lord, shall I read you, lord? Para 7 of the reasonings. PW1 in his further chief detailed how he got and his father inherited his share. That is plaintiff's father, Uddavannappa and Vannegoda are the brothers. Uddavannappa had 4 children, including plaintiff. And
Para 80 ಬಂದ್ಬಿಡಿ, para 80.
ಅದೇ ಬರ್ತದೆ ಯಾರು ಎಷ್ಟು ಶೇರ್ ಅಂತ. Take it to lordship, I am reading lordship. Children partitioned the family property. Suit schedule property has come to the share of first plaintiff jointly. The said partition deed produced and marked as Exhibit P4, Exhibit P5 is Exhibit P4. Exhibit P5 is property of his father. It is in further cross-examination of PW1. He deposed that in second property in the year 1967, he and the second plaintiff together got the share of 1 acre 21 guntas, and the said document is made in the year 1967 and further stated that whatever averred earlier on property between him and his father is false, and what he stated earlier that his father get the share of 1 acre 20 guntas is false, and it is also false that 1 acre 20 guntas is shared between the plaintiff brothers, and further stated 8990 partition between him and brothers is false, and there is no documents for the same. His brother Somashekara got 20 guntas and his cousin Puttaya 14 guntas. All these lands comes under 1/3B. 1/3B, the span claims alone in his individual capacity 1 acre 21 guntas.
According to them, when this partition took place, 1967.
1967.
Which is okay. It is evidence in Exhibit P5.
Yes.
Read Exhibit P5.
Exhibit P5. Paper book, my lord, I am not able to. Not available in the paper. Can I take the record and see below?
See, this is your case that they have partitioned more property than what is available in the family for partition. That is the case. You should have looked into the property itself.
Yes.
It was produced.
Property said to have been produced is a unregistered property.
Sincerely.
Exhibit B.
In your absence, what I said is.
Yes.
In the commission report.
Yes.
There is nothing on record to show that you have enclosed 13 gunta. So to that extent, the judgment is wrong. But there is an admission on your part to say that you have enclosed. You yourself say that in the cross-examination, you have suggested that the encroachment has taken place 3 years prior to the filing of this. That is your defense.
That's correct.
What you are trying to say is encroachment has not taken place as stated in the plain. It has taken place 3 years prior to the partition. Filing of this.
There is an encroachment, my lord.
You admit it.
Yes.
So what is the exact extent of encroachment that is not forthcoming in the survey sketch?
Survey sketch, my lord.
To that extent, the survey sketch is erroneous.
Yes.
But there is one more thing. The survey sketch is as per the scale. They have provided this scale.
Yes.
1 centimeter equal to 16 meters.
Yes.
So by referring to this scale, you can make out the extent. The defect of not mentioning the extent in the survey state, that can be taken care of because there is a reference to the scale. 1 centimeter equal to 10 meters, 1 meter ಅಂತ ಹೇಳ್ತಾರೆ. So
ಪ್ಯಾಸೇಜ್ ತರ ಬರ್ತದೆ ಅದು.
there is a method to calculate.
ಕಂಪ್ಲೀಟ್ ಸ್ಟ್ರಿಪ್ ಆಫ್ ಇದು ಹೋಗ್ತಾ ಸ್ವಲ್ಪ ಕೋರ್ಸ್ ಬರುತ್ತೆ ಅದು.
ಫಾರ್ಮುಲಾ ಇದೆ. ಕ್ಯಾಲ್ಕುಲೇಟ್ ಮಾಡಬೇಕು. ಅದ್ರ ಪ್ರಕಾರ ಮಾಡಬಹುದು, ಅಷ್ಟು ಕೊಡಬೇಕು, ವಾಪಸ್ ಕೊಡಬೇಕು. You admit in your cross examination that there is encroachment. ಅವರು ಕ್ರಾಸ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. You read the cross examination of plaintiff.
Okay. 0119. Complaint. 0117 you will have to take it, not a supervisor, survey supervisor was appointed ಅಂತ ಕರೀತಾರೆ.
ಅದು ನೋಡಿದೀನಿ.
ಅದನ್ನ ಅತಿಕ್ರಮಣ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಸರಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
ಇಲ್ಲ ಬಿಡಿ, ನೀವು ಕ್ರಾಸ್ ಮಾಡಿದಾಗ
ನಮ್ಮನ್ನ ರಾಜಣ್ಣ 0118 my lord message TW1, that is the appellant my lord. Uh, 01119 ವಾದಿಯ ತಂದೆ my lord got 019 my lord.
ನೀವು ಕ್ರಾಸ್ ಮಾಡಬೇಕಾದ್ರೆ when you cross examine the plaintiff.
Yes. Plaintiff cross examination ಮಾಡುವಾಗ ನಾವು what we have said is my lord, ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕಿದ ನಂತರ 13 ಕುಂಟೆ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡರು ಹೇಳಿರುವುದು ಸುಳ್ಳು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಸ್ಟೇಟ್ಮೆಂಟ್ 012 ಎಲ್ಲ. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ ಮುಂಚೆಯೇ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರು. ಈ ದಾವೆಯಲ್ಲಿ ಈ ಹಿಂದೆ ವಿಚಾರಣೆ
012
my lord, last 4 lines my lord, at least apart from the bottom 4-5 lines my lord. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕಿದ ನಂತರ my lord got it my lord. 13 ಕುಂಟೆ ಜಮೀನನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡರು ಎಂದು ಹೇಳಿರುವುದು ಸುಳ್ಳು ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ ಮುಂಚೆ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರು.
You admit.
Yes.
So you admit encroachment.
That is the reason my lord.
Next sentence.
Yes, next sentence also. ಈ ದಾವೆಯಲ್ಲಿ ಈ ಹಿಂದೆ ವಿಚಾರಣೆ ಆದಾಗ ಆಗಲೇ ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಆಸ್ತಿಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿದರು. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ 3 ವರ್ಷಗಳ ಹಿಂದೆ ದಾವಾ ಆಸ್ತಿಯನ್ನು ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರು. ನಾನು ಸುಳ್ಳು ಅಂಶಗಳನ್ನು ನೀಡಿ ಪ್ರತಿವಾದಿಗಳ ಆಸ್ತಿಯನ್ನು ಒಡೆಯಬೇಕೆಂಬ.
You admit. What is the extent of true property?
True property is 2 acres 21 according to the RTC.
No, according to the plain description.
According to the plain description, my lord, is 1 acre 21 guntas, my lord. 1 acre 21 guntas out of including 3 guntas.
See, then amendment is carried out. Plaintiff is amended.
No, this is the only plaintiff. There is no amendment to this.
Direct the defendants to hand over the possession. So there is an admission that you are in possession of the property as an encroacher.
Yes.
To the extent of 13 guntas.
13. That's what our entire claim is only that you are. We are not asking anything more or less.
No, you admit to be an encroacher.
Yes.
Then you have to vacate.
No, we are not the encroacher. It is they who are.
You are for defendant or plaintiff?
I am appearing for the defendant.
You say that you are the encroacher. What is the like?
It's correct, your lordship. This suit was filed by the respondent plaintiff's lordship here.
Page 012.
012.
Last 4 lines. ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ ಮುಂಚೆ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರು. So before understanding this, come to page 011.
I am the defendant, my lord. There is I.
Come to 011.
011. Yes, your lordship.
First sentence. Party ಸವಾಲು.
Yes, sir. I am reading that one.
No, KEB ವಕೀಲರಿಂದ
Yes, KEB ಅವರಿಂದ
Dependents lawyers.
ಅದನ್ನೇ ಓದ್ತಾ ಇದ್ದೀನಿ.
Dependents
ನಾವು
lawyers.
ಡಿಪೆಂಡೆಂಟ್ಸ್.
Correct. Next 212 ಬನ್ನಿ. 012 ಬನ್ನಿ ಈಗ.
013 ಮೇಲ.
012.
Yes.
Last 4 sentences which you read just now.
ಪ್ರತಿವಾದಿಗಳು ದಾವಾ ಹಾಕುವ ಮುಂಚೆ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡಿದ್ದರು.
This is your stand.
That's correct.
So you are the encroacher. How do you defend your encroachment?
So what they have done is not, there is a bund, according to us, not there is a bund.
You admit that the encroachment.
Even assuming that I have been in encroachment, but they are claiming that it is their property.
You admit that.
Yes.
You are admitting it.
That's why we sought for it. It is only a suit for injunction, your lordship.
Suit for possession.
Suit for injunction and possession, your lordship.
Declaration possession. They are entitled for a decree.
That is the admission made by them.
This is your suggestion by the advocate. This is assertion that you are.
In the beginning itself, I said I cannot improve what is already on record, your lordship. There is a law I could stretch it.
So anyway, this is adjourned on Monday. So the contention that they have apportioned more property, partitioned more property than what is available is not established.
Yes.
It's not established.
It's not established. Yes.
And that you are in possession as an encroacher is established because that is your case.
Yes. That's cover my case.
And if you are in possession as an encroacher,
yes,
their suit can be dismissed provided you have set up adverse possession.
That's correct.
Adverse possession is not pleaded.
Not pleaded.
Not established.
Yes.
So all these years you have enjoyed the property.
Yes.
Now it is time to vacate.
Yes. That's correct.
Yes.
Yes. Order 41, Rule 27 also, I filed one application, it appears not.
What is that?
Order 41, Rule 27, if your lordship takes up, my lord, only one para I would like to bring it to your lordship notice. That is valid.
Application for production. That is not listed. I have 5 of 16.
ಒಳಗಡೆ ಇರ್ಬೇಕು ಅದು. Already I think ಎರಡಂತ ಇರ್ಬೇಕು.
What you wanted to produce?
ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀನಿ. ಹಕ್ಕು ಬದಲಾವಣೆ ಬಗೆಯಲ್ಲಿ ಅವ್ರಿಗೆ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿತ್ತು ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಅವರ 4 ಜನ ಮಕ್ಕಳಿಗೆ ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಬಂದಿದೆ ಅನ್ನೋದಕ್ಕೆ ಇದರಲ್ಲಿದೆ ಇದರಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 1/3 ನಲ್ಲಿ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟೆಷ್ಟಿದೆ ಅಂತ ಸೋಮಶೇಖರಯ್ಯ ಅವ್ರಿಗೆ ಪಾಲ್ಗೆ ಎಷ್ಟು ಬಂದಿದೆ,
ಪ್ಲೇಂಟಿಫ್ ಯಾರು ಇದ್ರೊಳಗೆ,
ಅಣ್ಣ ತಮ್ಮ ಪ್ಲೇಂಟಿಫ್ ಇದರಲ್ಲಿ ಜೈಕುಮಾರ್ ಇದರಲ್ಲಿ plaintiff is a Jaykumar is a plaintiff number 2, my lord. Plaintiff number 2 is the Jaykumar.
ಅವರ ಹೆಸರಲ್ಲಿ ಇಲ್ಲಿ
ಅಲ್ಲಿ
ಮೃತ್ಯುಂಜಯ ಪುಟ್ಟಯ್ಯ.
ಜೈಕುಮಾರ್ ಅಂದ್ರೆ ಅವರ ಜೈಕುಮಾರ್ ಸಣ್ಣ ಮುದ್ದುವನ್ನಪ್ಪ ಪುಟ್ಟಯ್ಯ ಶೆಡ್ಯೂಲ್ ವಿಭಾಗ ಪತ್ರದ ಮೂಲಕ ಆಗಿರೋದು 1967 ಮೂಲಕ ಆಗಿರೋದು ಸ್ವಾಮಿ ಹೇಳಿದ್ದಾರೆ. ಹಕ್ಕು ಬದಲಾವಣೆ ಪ್ಲೇಂಟಿಫ್ ಹೆಸರು ಇಲ್ಲಿ ಪುಟ್ಟಯ್ಯ ಅಂತಿದೆ. ಮತ್ತೆ
ಪ್ಲೇಂಟಿಫ್ ಜಯಕುಮಾರ,
ಪ್ಲೇಂಟಿಫ್ ಜಯಕುಮಾರ್.
ಪೇಜ್ ನಂಬರ್ 80 ಬನ್ನಿ.
ಪೇಜ್ ನಂಬರ್ 80 ಬಲ್ಲ
8 ಟೈಪ್ ಕಾಪಿ ಹಾಕಿದಿರಲ್ಲ. ಸರ್ವೆ ನಂಬರ್
ಶೆಡ್ಯೂಲ್ ಮೃತ್ಯುಂಜಯ ಸಣ್ಣ ಮುದ್ದಪ್ಪ ಟೂವನ್ನಪ್ಪ ಜೈಕುಮಾರ್. ಅದರಲ್ಲಿ 1/3 3 ಎಕರೆ 16 ಕುಂಟೆ ಅಂತ ಇದೆ ಖುಷ್ಕಿ ಅಂತ.
ಸರಿಗೆ ಜಯಕುಮಾರ್ಗ
ಜೈಕುಮಾರ್ 9 ಪೇಜ್ ನಂಬರ್ 9 ಮೇಲೆ ಆಟ್ಪುಟ್ ಪೇಜ್ ನಂಬರ್ 9
3 ಎಕರೆ 16 ಗುಂಟಾ
3 ಎಕರೆ 16 ಗುಂಟಾಸ್ ಅಂತ ಇದೆ. ಅದರಲ್ಲಿ 1 ಎಕರೆ 20 ಕುಂಟೆ ಒಟ್ಟು ವಿಸ್ತೀರ್ಣದಲ್ಲಿ 1 ಎಕರೆ 20 ಕುಂಟೆ ಇವ್ರಿಗೆ ಭಾಗ ಅಂತ. ಪೈಕಿ ಅದು ಭಾಗ ಬಂದಿರೋದು ಇವ್ರಿಗೆ 1 ಎಕರೆ 20 ಕುಂಟೆ
ತೋರಿಸಿದೆ ಪೈಕಿ ಅಂತ.
ಇಲ್ಲಿ ಪೈಕಿ ಫಸ್ಟ್ ಇದೆ ನೋಡ್ಬೇಕು ಅದನ್ನ. ಇಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ಪ್ಯಾರಾ 7 ಮೇಲೆ ಆಡ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಅಲ್ಲ ಪೇಜ್ 7 ಅಲ್ಲಿ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡುವಾಗಿದೆ. ಪಂಚಾಯತಿ ವಿಭಾಗ ಪತ್ರದ ಪ್ರಕಾರ ಪೈಕಿ ಅಂದ್ರೆ ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಫಸ್ಟ್ ತೋರಿಸಿದ್ದಾರೆ 1 ಎಕರೆ 16 ಕುಂಟೆ.
ಒಬ್ರಿಗೆ 14 ಕುಂಟೆ
ಅದೇ 1 ಎಕರೆ 20 ಕುಂಟೆ ತೋರಿಸ್ತಾರೆ. ಒಂದು
ಸೆಕೆಂಡ್ 14 ಕುಂಟೆ. ಮತ್ತೊಂದು ಶಹರಿಗೆ 31 ಗುಂಟಾಸ್.
ಒಬ್ಬರಿಗೆ 1/3 ನಲ್ಲಿ 30 ಕುಂಟೆ ತೋರಿಸ್ತಾರೆ. ಇಲ್ಲಿ 30 ಗುಂಟಾಸು. ಸೋಮಶೇಖರಯ್ಯ ಅನ್ನೋರ್ಗೆ 30 ಕುಂಟೆ ತೋರಿಸ್ತಾರೆ. ಮೃತ್ಯುಂಜಯ ಅನ್ನೋರ್ಗೆ 1/3 ನಲ್ಲಿ 31 ಗುಂಟಾಸ್ ತೋರಿಸ್ತಾರೆ.
ಸಂಜಯ್ ಬೇಡ ಜಯಕುಮಾರ್ ಬನ್ನಿ.
ಆ ಜಯಕುಮಾರ್ದು 1 ಎಕರೆ 20 ಗುಂಟೆ ತೋರಿಸ್ತಾರೆ.
ಎಷ್ಟಾಯ್ತು?
1 ಎಕರೆ 20 ಗುಂಟೆ.
ಟೋಟಲ್ ಎಷ್ಟಾಯ್ತು ಈಗ?
1 ಎಕರೆ 20 ಪ್ಲಸ್ 30.
There are 4 sharers ಅಲ್ವಾ?
4 sharers. 30, 60 ಪ್ಲಸ್ 2 ಎಕರೆ 3 ಎಕರೆ ಆಗೋಯ್ತು. 3 ಎಕರೆ.
3 ಎಕರೆ 14 ಗುಂಟೆ ಇದೆ.
3 ಎಕರೆ 14 ಗುಂಟೆ ಇದೆ. ಅದು ಇನ್ನೊಬ್ರಿಗೆ ಹೋಗಿದೆ ಇಲ್ಲಿ. 1/3 ಪೇಜ್ 14 ಗುಂಟೆ ಹೋಗಿದೆ ಒಬ್ಬರಿಗೆ. ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲೇ ಇದೆ. ಪೇಜ್ 7 ಅಲ್ಲಿ. ಪೇಜ್ 7 ಅಲ್ಲಿ 14 ಗುಂಟೆ ಪುಟ್ಟಯ್ಯ ಅವ್ರಿಗೆ ಹೋಗಿದೆ.
125 ಗುಂಟಾಸ್ ಆಯ್ತು.
ಉಂಟು.
Divided by 40.
40. 1 acre is equal to 40.
3 ಎಕರೆ 12 ಗುಂಟೆ.
3 ಎಕರೆ 12 ಗುಂಟೆ. ಇಲ್ಲಿ ಡಿವೈಡ್ ಆಗಿದೆ ಅಂತ 3 ಎಕರೆ 12 ಗುಂಟೆ. ಬಟ್ ವಾಟ್ ದೇ ಸಿ 3 ಎಕರೆ 21 ಗುಂಟಾಸ್ ದೇ ಕ್ಲೈಮ್. How this 21 gunters came into picture is the question.
No. What is available is 3 acre 16 guntas.
Yes, exactly.
4 guntas kharab.
Yeah, that's.
So what is divided is 3 acre 12 guntas.
12 gunters. Correct. ಅದ್ರಲ್ಲಿ 4 ಗುಂಟೆ, ಅದ್ರಲ್ಲಿ 4 ಗುಂಟೆ ಖರಾಬು.
ಇದು ಎಕ್ಸೆಸ್.
ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ 4 ಗುಂಟೆ ಖರಾಬ್ ಇದೆ. ಅದನ್ನ 16 ಗುಂಟೆ ಆಯ್ತು. 316
ಇಲ್ಲಿ 4 ಗುಂಟೆ ಖರಾಬು.
yes, correct.
Total is 312.
ಇಲ್ಲಿ ತೋರಿಸ್ತಾ ಇರೋದು
312 ಅಂತಂದ್ರೆ 120 plus 12 132 ಗುಂಟಾಸ್.
ಇವರು
ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಎಷ್ಟು ನೋಡಿ. ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ಕಮ್ ಟು ಪೇಜ್ ನಂಬರ್ 7.
ಎಸ್, ಪೇಜ್ ನಂಬರ್ 7 ಇಲ್ಲ.
ಒಬ್ಬರಿಗೆ 14 ಗುಂಟಾಸ್.
ಒಬ್ಬರಿಗೆ 14 ಗುಂಟಾಸ್ ಇದೆ.
ನೆಕ್ಸ್ಟ್
ಇನ್ನೊಬ್ರು 31 ಗುಂಟಾಸ್.
ಒಂದ್ ಸೆಕೆಂಡ್.
ಮೃತ್ಯುಂಜಯ 31.
ಸೆಕೆಂಡ್. ಮೃತ್ಯುಂಜಯ
31
ಗುಂಟಾಸ್.
ಎಸ್ ಅಂಡ್ ಸೋಮಶೇಖರಯ್ಯ 30. ಅಂಡ್ ಜಯಕುಮಾರ್ plaintiff my lord 1 acre 20 guntas. 1 acre 20 guntas.
140 ಆಯ್ತು. ಸಾರಿ 60.
1 acre 20 ಅಂದ್ರೆ 60 guntas. ಒಬ್ಬರಿಗೆ ಮೇಜರ್, ಉಳಿದವ್ರಿಗೆ 3 ಎಕರೆ, ಒಬ್ಬರಿಗೆ 14 ಗುಂಟೆ.
ಟೋಟಲ್ 135 ಆಯ್ತು.
ಆಯ್ತು.
ಟೋಟಲ್ 135.
ಇನ್ ದಿ ಪ್ಲೇಂಟ್
ಜಸ್ಟ್ ಎ ಸೆಕೆಂಡ್. ಫ್ಯಾಮಿಲಿಗೆ ಇರೋದು
3 ಎಕರೆ 12 ಗುಂಟೆ.
plus 3 guntas
and 4 guntas or 3 guntas of kharab land. ಇವರು 3 ಎಕರೆ 21 ಗುಂಟೆ ಹೇಳ್ತಾ ಇರೋದು. ವೇರ್ ಇಟ್ ಕಮ್ಸ್ ಅಂತ ಅನ್ನೋದು ಪ್ರಶ್ನೆ.
321 ಹೇಳ್ತಾ ಇಲ್ಲ ಸರ್. 120.
120 ಲಾರ್ಡ್ಶಿಪ್ ಟೇಕ್ಸ್ ಇಟ್ ಟು ಕನ್ಸಿಡರೇಷನ್ ದಿ ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿ ಅಲೋಕೇಶನ್. 121 ಬರಬೇಕು. ಬಟ್ ಇಫ್ ಲಾರ್ಡ್ಶಿಪ್ ಲುಕ್ ಅಟ್ ದೇ ಆರ್ ಪ್ಲೀಡಿಂಗ್, ಹೌ ಕಮ್ ದಿಸ್ 121 ಕೇಮ್ ಇನ್ ಟು ಪಿಕ್ಚರ್? ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಶೆಡ್ಯೂಲ್.
3 ಎಕರೆ 15 ಗುಂಟೆ ಹಂಚ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇವ್ರು 1 ಎಕರೆ ಇವ್ರಿಗೆ ಜಯಕುಮಾರ್ಗೆ ತಗೊಳ್ಳೋದಾದ್ರೆ
ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ ಡಿವೈಡೆಡ್ ಬೈ ದಮ್ ಈಸ್ 135 ಗುಂಟಾಸ್. 135 ಗುಂಟಾಸ್ ಅಂತಂದ್ರೆ 40
ಖರಾಬು ಸೇರಿ ಅಂತ.
135 ಗುಂಟಾಸ್ ಅಂತಂದ್ರೆ
ಬಟ್ ದೇ ವಾಂಟ್ ಸೇ
3 acres 15 ಗುಂಟಾಸ್.
ಇಲ್ಲಿ ಅವರು ಹೇಳುದು ಇಲ್ಲಿ ಖರಾಬು ಸೇರಿ ಹಂಚ್ಕೊಂಡಿದೀವಿ ಅಂತ ಹೇಳುದಿಲ್ಲ. 3 acres 12 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್. 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಯಕುಮಾರ್ ಪ್ಲೇಂಟಿಫ್ ಹೋಗಿದೆ. ಇನ್ನೊಬ್ಬ ಪುಟ್ಟಯ್ಯ ಅನ್ನೋರ್ಗೆ 30 ಗುಂಟೆ ಹೋಗಿದೆ. ಸೋಮಶೇಖರ್ನವ್ರಿಗೆ 30 ಗುಂಟೆ ಹೋಗಿದೆ. ಅಲ್ಲಿಗೆ 60 120 ಅದು 60 ಆಯ್ತು. ಇವರಿಬ್ರು 3, ಇನ್ನೊಬ್ರಿಗೆ 14 ಗುಂಟೆ ಹೋಗಿದೆ.
What we will say is,
yes,
while conducting this survey,
yes,
kharab is to be excluded ಅಂತ ಹೇಳೋಣ.
Kharab has to be excluded. If kharab is excluded, then original figure will come.
Real figure ಎಷ್ಟಾಗುತ್ತೆ? 312 ಆಗುತ್ತೆ.
312. They have shared that only.
122 ಗುಂಟಾಸ್ ಆಗುತ್ತೆ.
30, 30, 60, 74 ಪ್ಲಸ್ 60 ಟೋಟಲ್ 4 ಜನರಿದ್ದಾರೆ.
3 ಗುಂಟೆ ತೆಗೆದ್ರೆ what is available is 3 acre 12 ಗುಂಟಾಸ್.
Yes, exactly.
120 plus 12.
Yes, ಅಷ್ಟಕ್ಕೆ
122 ಗುಂಟಾಸ್ ಆಗುತ್ತೆ.
Yes.
ಡಿಫರೆನ್ಸ್ ಇರ್ಕಲ್ಲಿ 3 ಗುಂಟೆಗೆ ಮಾತ್ರ.
3 ಗುಂಟೆ ಡಿಫರೆನ್ಸ್ ಬರ್ತದೆ. ಬಟ್ RTC ಹೋದ್ರೆ ಜಾಸ್ತಿ ಬರ್ತದೆ.
3 ಗುಂಟೆ ಖರಾಬು ಹಂಚ್ಕೊಂಡಿರ್ಬೇಕು ಅಷ್ಟೇ.
ಖರಾಬನ್ನ ಹಂಚ್ಕೊಳ್ತಾರೆ.
Why for that kharab is mentioned? Why that kharab is
ಖರಾಬನ್ನ ಹಂಚಿದೀವಿ ಅಂತ ಹೇಳುದಿಲ್ಲ ಅವರು.
Why that kharab is mentioned?
ಖರಾಬು ಅದರಲ್ಲಿ ಅವ್ರು ಏನ್ ಖರಾಬ್ ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಇಲ್ಲಿ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಕೋರ್ಟ್ ಖರಾಬ್ ಅಂತ ಹೇಳ್ತಾರೆ.
What purpose?
ಕೋರ್ಟ್ ಖರಾಬ್ ಅಂದ್ರೆ ಅದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂತ ಅದನ್ನ ಹೇಳುದಿಲ್ಲ ಅವರು. They don't say specifically what type of kharab.
What you say?
Whether this kharab is according to the nature of the land which we have explained, Lord, it appears to be a stream or something. That kharab does not run with the land. They are not entitled for the share.
Kharab cannot be partitioned.
Yes, Your Lord.
So what we will say is,
yes,
that excluding 3 guntas of kharab, remaining
excluding 4 guntas.
4 guntas kharab ho.
Excluding 4 guntas of
Yes.
remaining portion you have to hand over.
So I have filed a suit for declaration.
No, you are not filed. You are for
No,
dependent.
the respondent filed a suit, my lord, and against me for declaration and possession. They did not challenge this order, your lordship. The 3 acres 12 guntas total extent, my lord, the remaining extent, your lord. 3 acres 12 guntas.
3 acres 12 guntas is to be apportioned.
Apportioned.
They have taken 3 guntas more.
3 or 4 guntas any amount.
The decree for possession
Yes.
has to be excluded in respect of Kharab land.
Kharab land.
Kharab land, if it is in your possession, you have to opt out.
It has to be given. There is no other go.
Nobody can claim right over that.
Nobody can. Because though I am a owner of property of survey number 1/4, if that Kharab land being the stream or Allah.
So what we will say is,
Yes.
you have to hand over the possession.
The possession, let them take it. Let them.
No, through the process.
During the process, it is for them, my lord. Once.
Just a second. You have to hand over the possession of the extent of land in your possession in survey number 1/3B, excluding Kharab. Kharab will be meant for maintaining the stream.
Maintain the stream or whatever Kharab it is there, it is.
It is for the benefit of both.
Yes. Owner in possession. What they say is, my lord, handing over, my lord, they are not asked for, they are not sought for recovery.
But they are sought for recovery.
No, so my lord,
Last para.
owner in possession, my lord.
Last para.
Direct the respondent or the dependent to hand over the vacant possession of 13 guntas at the end. There is no 13 guntas.
See, you say in the cross-examination that you are in possession of the property, suit property. Suit property is 13 guntas when it comes to possession.
Correct.
You admitted.
But if they ask for handing over the vacant possession of the property, they would not have sought for declaring that they are the owner in possession. They should not have, because possession is with me.
That is remaining portion.
Remaining portion of 13 guntas.
Remaining portion excluding 13 guntas. See, they seek declaration in respect of 1 acre 20 guntas.
21 guntas.
1 acre 20 more, partition.
1 acre 20 guntas or partition. Yes, sir.
When they remind these 2 points, don't.
No, I will remind you, Lord. I will remind you.
1 acre 20 guntas is the property allotted to them. 1 acre 21 guntas is
My lord may make it note, my lord.
for which he is seeking declaration.
The memory is
the additional document produced by the respondent would indicate that 1 acre 20 gunta is allotted to the share of plaintiff in the family partition. However, the declaration is sought in respect of 1 acre 21 guntas. Next point. The total extent of land in survey number 1/3 before subdivision is 3 acres 16 guntas, which is inclusive of 3 guntas Kharab.
So 4 guntas, according to the
4 guntas of Kharab. So what was allowable for partition was 3 acre 12 guntas. And what is apportioned among the family members is 3 acre 15 guntas.
3 acres 15. 3 acres 15 guntas. 14 gunte, 30 gunte plus 1 acre 20 gunte.
3 acre 15 guntas. Then 3 gunte ಜಾಸ್ತಿ ಮಾಡ್ಕೊಂಡು
3 gunte ಜಾಸ್ತಿ ಮಾಡ್ಕೊಂಡು. Number 53 was there.
ಏನಾಯ್ತು?
53 ಇಷ್ಟ ಆಗಿಲ್ಲ. Whereas the concurrent finding, the appeal has been filed by the appellants also. Half share has been declared. A suit for partition.
ಪಾರ್ಟಿ ಬೆಳಗ್ಗೆ ಬಂದು ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಅಂತ ಅಡ್ವೊಕೇಟ್ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಅಂತ
Date is given, it will be.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ನೋಡಲ್ಲ ಸೆಕೆಂಡ್ ವೀಕ್ ಸಿಗ್ನೇಚರ್ ಆಗುತ್ತೆ.
Okay.
Where? Not here. Arun Kumar.